ಮಂಗಳೂರು ಯೂನಿವರ್ಸಿಟಿಗೆ ಯಾರು? ಮಂಗಳೂರು ಯೂನಿವರ್ಸಿಟಿಗೆ ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸ್ವಾಮಿ ಇದ್ದಾರಾ ಅಥವಾ ಇಲ್ವಾ? ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
Court officer, sir, is it audible, please?
Yes, sir. Yes, sir.
Thank you, sir. Thank you very much.
ಲಾಗಿನ್ ಆಗಕ್ಕೆ ನಮ್ಮ ಕೋರ್ಟ್ಗ ಅದು ಅವ್ರವ್ರಿಗೆ ಆನ್ ಮಾಡಿ, ಮ್ಯೂಟ್ ಆನ್ ಮಾಡಿ.
I mean, Monday, 28/10 ಗೆ interim order expire ಆಗುತ್ತೆ. Continuously 2 days memo move ಮಾಡಿ. 2:30 today 2:30.
ಇಲ್ಲ submission. ಇಲ್ಲಿ ಮಾಡ್ತೀರಾ?
2:30.
My lord, this is the matter pertaining to pensionary benefits, my lord, of Group D employees. They are all retired employees. Next week, madam, please. Oblige, madam.
Gentlemen's list 1, page number 1. 1 to 6, page number 2, page number 7 to 14, page number 3, 15 to 19, page number 4, 20 to 23, page number 5, 24 to 30, page number 6, 31 to 36, page number 7, 37 to 40, page number 8, 41 to 44, page number 9, 45 to 49.
49.
Now just wait. Only on that point, they wanted some.
Let it be on 8th at least, my
No,
lord.
correct. They want some. I'm not going to hear the other matter.
Okay.
They filed one IA.
Ah.
Only on that IA I'll consider and refix the date on the original date. Whatever original date it is.
It's an impleading application by then.
No, they're seeking
Huh?
release of maintenance.
No, Milord, they don't have a locus standi. I have already filed my objections. I want to have.
Not-
Milord, last time itself I explained, I have a family functions already going on. My sons have landed today morning. I had come only because respecting somebody had sent me a mail today. So my humble prayer is, Milord, any date after 15 is, because by the time my family, everybody will go back. My 60th birthday celebrations are on in the family. So it's my, no, Milord, they don't have a locus standi. They cannot simply rush. No, it is not, Milord. It is actually not. They don't have a locus standi. I want to strongly argue with us.
No, that's okay. That we'll see. So we'll have it on 16th. We'll see. No, he wants to argue on that.
Because detailed argue, because it is on a
Let us see.
fabricated.
So let us see. If it requires hearing, then we'll
Yes,
hear.
it
On
does
16.
require, Milord.
16th. And
All the matters.
19th.
19th fine.
19th.
Obliged, Milord.
All the matters.
He wants to argue. Now, if he's going to argue, just 1 minute. Now, if he has to argue, then it's not possible today. I thought we could take it up, but since it's contested, then we'll have to hear and pass a considered order. Nineteenth. Yes.
Page number 10, page number 51.
51, my lord. 2 weeks time may be given, my lord. For the respond number 2, 51 and 51.1. Some personal.
You have informed the other side.
Now itself I'll inform, my lord.
You have to, in my court, you have to inform in advance. Inform and report to the court office. Yes, release the matter. Inform and report to the court office.
Right.
Page number 11, 52 and 53. Page number 12, 54. Page number 13, 55 to 58. Page number 14, 59 to 63.
My lord, serial number 59, my lords. I appear for respondent number 2. I've informed the petitioner, my lords. If your lordship could
You
have
have
it.
informed,
Please, my lords, I've
Ah.
informed.
release the matter on.
Serial number 61.
Yes.
The last of it, the government had taken time to fight their objections. So
And
is it-
Need 2 weeks in this matter, my lord.
Relist the matter on 20th.
Page number 15, 64 to 66. Page number 16, 67 to 70. 6 to 2. Page number 1, 1 to 7. Page number 2, 8 to 80. Page number 3, 19 to 24. Page number 4, 25 to 28.
My lords, serial number 28. I appear for the petitioner. I have not received the hand summons back, my lords. I request for 3 weeks of time, my lords.
Relist the matter after 3 weeks. Office to put up report regarding notice issued to R1 to R3.
Page number 5.
Watch up.
That's it, serial number 23, my lord. Serial number 23, my lord. List number 2. List number 2, serial number 23, my lord. It is, the parties are in for a compromise, my lord, if it can be posted next week, my lord.
You appear for?
I am appear for the petitioner, my lord. Somewhere November 7th, my lord.
Relist the matter on
7. Page number 5, 29 to 34. Page number 6, 35 to 43. Page number 7, 44 to 50.
at request release the matter.
14.
May I make one mention?
Just wait, just 44 to 50.
Page number 7, 44 to 50.
Yes,
Not one matter, not earlier, but whatever the facilities granted was withdrawn. This honorable court and the earlier round directed them to redo it, but they have not done it. But contempt was filed.
could it?
But for orders any day next week.
Could it?
My lords, matter, my lords, I moved it twice, my lords. The junior engineers matter, we have challenged the seniority list and now KPTCL is proceeding with the promotion to private respondents, my lords. It was supposed to be listed today, it has not come. For Monday at least, my lords. Please. Your
file, You come and check once at 1:30.
Please.
You have to come and follow up once.
Please, man. We checked it yesterday, it was not, please.
Or ಕೇಳಿ ಏನಕ್ಕೆ post ಆಗಿದೆ?
Next one, fresh matter serial number 1. Kashinath JD.
Hearing for petition.
Who appears? BWC.
This, my lord.
You serve a copy on Sanjeev, I'll have it on Monday.
After filing of this petition, my lord, they have withdrawn the impugned order.
Withdrawn.
Yes, I'm not pressed.
Counsel for the petitioner files a memo and is submitted that the order of transfer has been withdrawn.
Yes,
In light of the same, petition is dismissed.
The petitioner has retired in April, my lord, his pensionary benefits not. But there is absolutely, in fact, even AG has permitted to.
AG is directed to accept notice for the respondents. Now, this is a matter where he's retired and some inquiry proceedings are pending regarding his caste certificate.
No, not pending.
So, they, on that ground, it appears that you have withheld. But I think this is a settled position. You make a compilation of judgments. Some of them say that the fag end, if it is done also, you can't intervene. So you, on that position of law, you make a small compilation of judgments. This appears, this inquiry proceedings, whatever initiated on the complaint is at the fag end.
Allah, it is now over, my lord. It is now over. All in my favor. In fact, there is an observation by this
Correct,
court.
some appeal is pending.
No, kindly see, my lord, the order of this honorable court, which I have produced.
No, so let's see. So,
Page 26, man.
so prima facie, you can't after he has retired, rendered service. Now, if the caste certificate, any defect is, if at all, it should have been pointed out at the earliest point.
Yes.
Whatever it is, not after he retires. In the multiple rounds of
This-
litigation.
But 1 second, page 26, ma'am, page 26. My lord, can I just read 20? This court wide order dated 13/8/24 allowed the writ petition wherein the operative portion at page number 10, the following para number 3 needs to be added. it is needless to state that the petitioner is entitled for all the benefits following his retirement from service. This is the order of this honorable court. If I produce everything and two matters were pending against me, that is now over and held in my favor. But
List the matter in the orders list. After 10 days, I'll fix a date, complete your instruction.
some date, my lord.
Yes, sir.
14.
You make one small compilation apart from the list of dates on the legal position as well. Yes.
But some earlier they should.
No, they have to complete. So whenever they, let them complete it so that, let them complete the instruction so we can dispose it of.
That's my lord.
Allah, correct. Now they have to complete. So
I will give the compilation. There's nothing to be done by this.
now their clients, not the government agency. Yes. List.
Appear for the petitioner, my lord, serial number 3. My apologies, my lords. I'm appearing through VC, my lords. On the way, I hurt my leg, my lord. That's why I'm appearing through VC, my lords. My
Why
apologies.
apology? I am very comfortable with VCA, and I request if you are comfortable, we are also comfortable.
My lords.
You take out notice.
My lords, respond number 225, my lords. Purnima in a connected matter, my lords. Writ petition 6602 of 2024. My lords, Purnima HS has taken notice, my lords.
Then Council Purnima HS is directed to accept notice for respondent
225.
5. AGM
1 AGM.
First respondent. Yes.
Deeply obliged.
For
the petitioner. Let be. The challenge is to the endorsement at Annexure B. My lord, on the previous occasion, it so happened.
Take out notice.
Very well, please.
AG is directed to accept notice for respondent 1 and 2. Learned Council MP Geeta Devi for the third respondent.
Please. I request for some date. Very wait.
5.
So I'm appearing for the petitioner in this matter.
You take out notice, I'll have it in the orders list. Let's hear them before we consider your interim relief. I'll give a short date. We'll hear them. Let us.
Lordship, then the consideration for interim prayer may be kept open.
Mangalore University. Now, who are the private respondents?
Private respondents are the other drivers who have been promoted and regularized, who are junior to me, who joined the service after me, and they have been regularized.
No, then matter would require them to take their stand in writing, and we have to hear, isn't it? Now, if they have been appointed, we can't stay, nor can we have two people working for the same post. But we may have to complete the pleading, give short dates, and then take up the matter finally.
Lordship, therefore, I'm seeking for interim prayer because.
But now somebody is appointed.
No, these since 2014, they have all been working as a driver in Mangalore University.
Let us
except now these have been regularized. I have not been regularized. I have been dismissed.
Let us Vice Chancellor Mangalore University. And then Council so and so is directed to accept notice for respondent 1 and 2. Emergent notice to 3 and 4. Request for interim prayer is kept open.
Please, and IA for dispensation may be allowed now because the certified copy have not been provided by the respondent.
24 is allowed petitioners dispense with production of certified copy of Annexure A, subject to the undertaking that the same would be produced in due course.
6.
Please.
3 nallu and order 3 nallu dispensation. Take out notice. Yes. Then Council TP Muttanna is directed to accept notice for respondent 1, 2, and 3. This week after next. Date code.
14. 7.
Petitioner in this matter. Question of transfer from one B category temple to a B8 category temple. My case is they could not have been transferred for a
Let us, you take out notice, we'll fix a date, we'll have it in the orders list. And
please, madam. Some date, short date may be given.
AG is directed to accept notice for respondent 1 and 2.
Please, madam. All respondents. You can take
Third also, that's a
third also. I think it's part of the.
Ah.
We can take it.
respondents 1, 2, 3.
I know it's not the third respondent, just 1 and 2.
It's a Muzirai temple.
I know, it's a A category temple.
Okay.
I will take notice on separately on third respondent.
AGA for 1 and 2. Emergent notice, third respondent, petitioner permitted to take out notice by way of handsome third respondent as well. Orders passed by government.
Orders passed by the commissioner. That is, here, according to me, deputy commissioner has got the powers. Now here in this case, commissioner has passed out.
It's the matter in the orders list on
Short date.
Next week.
7th.
Appear for the respondent 2 minutes.
Document.
I'll pass over, let Vishnu, but you appear.
Yes, my lord, I represent him. So they
What
will
do you say regarding jurisdiction? Jurisdiction, what do you say?
ಸ್ವಾಮಿ ಫಿಸಿಕಲ್ ಇವಾಗ 40% ಇರೋದ್ರಿಂದ ತಾವು ದಯವಿಟ್ಟು ನಾನು ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ನಮ್ಗೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಬೋದು ಫಿಸಿಕಲ್ ಹ್ಯಾಂಡ್
Make it good. No, I'm saying that this court has no jurisdiction. You have to go before the CAT. This court has no power to intervene. You will have to go before the CAT.
ಸ್ವಾಮಿ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ನನ್ನ ಇಲ್ಲೇ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ ಡಿಸೆಬಿಲಿಟಿ ಇರೋದ್ರಿಂದ ಮೆಡಿಕಲ್ ರಿಕಾರ್ಡ್ಸ್ ಎಲ್ಲ
Matter of jurisdiction. If I had the jurisdiction, it's a different matter. It's notified that the service disputes of this authority go before the CAT. How we can entertain the petition?
ಆಯ್ತು ಸ್ವಾಮಿ ಅಲ್ಲಿ ಹೋಗೋವರ್ಗು ಅಪ್ರೋಚ್ ಆಗೋವರ್ಗು ನಾನು ಲಿಬರ್ಟಿ
We have no jurisdiction. So you move the CAT forthwith. I'll release the order today itself. You will have to move the CAT. I don't know how you approach this court.
ಸ್ವಾಮಿ CAT ಹೋಗೋವರ್ಗು ಹಂಬಲ್ ಸಬ್ಮಿಷನ್
We have no
ಲಿಬರ್ಟಿ
jurisdiction.
ಕೊಡಿ ಸ್ವಾಮಿ ನಾನು
We have no jurisdiction to entertain it at all. When we have no jurisdiction, how I can give you protection? I don't know how it was entertained at the first instance at all. I'll release it today. Immediately you take steps.
ಅಪ್ರೋಚ್ ಆಗೋವರ್ಗು ನಾನು ಬನ್ನಿ
I have no jurisdiction to have it. No, I have no jurisdiction to entertain it. Ivatte release. Yes, next. I have recalling the order is rejected in light of the position that the jurisdiction lies before the Central Administrative Tribunal. Yes, next.
9.
Not grateful.
For petitioner.
Take out notice.
ಅಲ್ಲ ನೋಟಿಸ್ ಆಗಿ ಬಂದಿರೋದು.
Huh?
ಲಾಸ್ಟ್ ಟೈಮ್ ಗವರ್ಮೆಂಟ್ ಟುಕ್ ಟೈಮ್. ನೋಟಿಸ್ ಎಲ್ಲ ಆಗಿದೆ.
Agidya?
Yes. This is, I think, third time it is coming.
To receive.
My lord, only issue is, my lord,
Yes. No, let them complete their instructions. Complete your instructions.
Yes.
my lord, last time also they took time.
Relist on. You complete your instructions by the next date.
Yes, ma'am. I'll take notice, ma'am, for this.
We have already ordered.
Oh, very.
Yes. GA to complete instructions by the next date. Out of 2 posts, 1 you have already approved.
Yes.
Other, why not is the only question.
Yes.
By next date, you complete the instruction.
Very good.
Relist on.
Yes, ma'am.
10, serial number 10.
Yes, I pay for petition, my lord. Lord, first, my lord, till Monday, my lord, I request for this honorable court to adjourn the matter. I will produce, my lord, some
We'll have it on Monday.
Monday or Tuesday. Since my lord, since your lordship has directed me to produce some citations more with regard to interim relief can be granted by the appellate authority.
Relist on Tuesday.
Much of.
I think under the PTCL Act, there is an appeal provision, but there is no specific power to grant interim prayer. However, there's some judgment of the High Court which says that once the power of appeal is
Well,
there
yes.
under Section 5, then the power to grant interim order is inherent. Just check it out.
That is what my lord.
No, no,
My
check
lords.
it out. Now that's your duty, your homework.
Yes, yes.
You must point out in law. Then we can ask them to consider. Because
lords,
as
if-
of now, under the statutory scheme, no such power is there. So you will have to make out
Yes,
yourself. Tuesday.
May I only make one submission, my lords? These are proceedings under the POSH Act, my lords. Now, what the petitioner is challenging is the order of transfer itself.
No, no,
Now
that will not interfere.
That's the relief presently what the petitioner is seeking. Now, my lords, to send him back to the same place where there's an IC report saying that he's guilty of
But,
it.
that we cannot.
Yes, my
But if
lords.
at all, he was saying that he has filed an appeal, there was no interim prayer.
That is the interim prayer, my lord, to stay the order of transfer.
No, no, correct.
Ah.
He is requesting, but we are not inclined to do that unless we were of the view that maybe we can make an observation that since the appeal is pending, whether the appellate authority can consider.
Very well.
Then you pointed out that there is no provision.
Yes, my lords.
So we have asked him to do his homework to point out whether power to grant stay by the appellate authority may
So there
be
is-
construed.
Yes.
If that is so, we can ask the authority to construe.
Very well.
On that point, we have asked him to convince the court.
Very well.
So we'll have it on Tuesday, have a look at it,
I will.
have a look at some judgments under Section 5 of the PTCL.
Much of.
Somewhere I remember, but anyhow find it.
Grateful.
Yes, next.
11. Srinivasaki.
Next week, Nenne copy, sir.
Now, is it covered?
It's covered by the judge.
There are,
Correct. Whether this is group B, C, which is this?
Lord, this is
That
not
is B,
judgment of the apex court.
Rafiq
respect
Mashia's
of
case.
C and D group. C and D, my lord.
Group C and D.
Uh,
I also come under Group C, my lord. I am a retired junior engineer.
Find out.
No, I have to ascertain. And,
Find out.
and the other aspect is, my lord, refixation, my lord, that the judgment is not applicable.
That judgment
Only
I will-
recover of arrears of, my lord, excess pay, that Rafiq Mash case is applicable in respect of C and D group employees. Insofar as refixation of salary, my lord, that is not applicable.
No, correct. So suppose you do refixation, it will only be prospective.
Prospective, that's what.
That will clarify.
Yes,
Perspective only.
It's only on the point of
Yes.
recovery.
I
Are you-
already retired from service because there is no question of my lord refixing my salary,
That
which
can
I
be.
was drawing in 2010.
That-
They cannot do retrospectively.
Anyhow, completed instead. Relist
Friday, my lord.
on 8th.
Public.
You appear for BESCOM. is it?
Just come and keep it,
And keep it.
keep it.
12. Sagar, Pawan Kumar.
The order of suspension, my lords, is impugned. My lords, on 22/11/2022, my lords, an application was made, my lords, for issuance of bifurcation of kata.
No, just a minute. I'll pass over, you bring him.
Very well. So I've served him a copy, my lords, I'll get him.
Bring him.
Yes, yes, I'll get him.
13. Chetan Patel.
My lord, I'm petitioner for serial number 13, my lord. I pray for 2 weeks time to do the needful, my lord.
2 weeks time granted to do the needful.
14.
May kindly pass for carry out amendment today itself, madam.
Huh?
I want to carry out amendment, madam. May kindly pass for.
Correct. What is this matter? 2012 matter? Huh? Pass over. Carry out the amendment.
For carry out.
But on the merits, what is the matter on merits now? That will permit you. What is the matter on merits?
May kindly pass for senior.
Pass over. All ಆಯ್ತು 10 ವರ್ಷ ನಾನು ಜಡ್ಜ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಎಸ್
15. C. Rajendra. 15. Aditya Singh.
Password.
16. M. Subramanian.
Yes, but right now, here itself,
Petitioner is permitted to amend the cause title. What is the main matter?
Main matters on disciplinary proceeding, an order of dismissal has been challenged. Any date may be fixed.
This is the matter. In B group, a final hearing.
Final hearing rules been issued.
In final hearing list. On date.
14.
Meanwhile, do it now itself.
I shall do it.
Yes.
Great.
My lords, I appear for the respondent. My lords, in this, my instructions are that he was promoted to class 3 from class 4. His petition is for a switchover post, and that is in effect transpired with effect from 18/5/2017.
Why court notice?
I'm not very sure on that, my lords.
No, but now it appears that there is some order stating that the counsel for the petitioner had passed away. That's why court notice. ಏನಾಯ್ತು court notice? ಆಗಿದೆ. Now, otherwise we'll dismiss it for non-prosecution rather than saying anything on merits. If he's agreed, let him come and reopen it.
Very well, my lords. In any case, even on merits, I think it would become infructuous because he's got his promotion.
It appears that the court notice issued to the petitioner has been delivered. In light of the same, the petition is dismissed for non-prosecution as the petitioner has not made any arrangements to engage in other counsel. Yavat sarvagiride? 2/5/2020.
18. Subramanian.
Obligement.
Serial number 18. Subramanian.
Yes, there appears to be some objections in the application filed by the government for early hearing. Now it is of 2013. Any date may be fixed for finally.
It should come in final hearing or?
Yes, final hearing.
List the matter in final hearing list on. Now, whether this R5 in the connected matter.
Yes.
Is it a necessary party?
No, it is a management, so therefore it may be
Necessary
required.
party?
Yes,
Huh?
please.
Then government, you have ensured that he aided.
Aided.
Government to ensure that notice to R5 in 58403 of 2015 is served through the block education officer of registry to issue hand summons to enable government to complete service on R5 in 18.1.
Yes.
Relist the matter in final hearing list on.
Grateful.
Serial number 19. Jay Kumar Ji.
For the respondent number 4 and 5.
Respondent number
4 and 5. My lord, these writ petitions become infructuous. Not earlier, they are challenging only the issuance of the verification list. Subsequent to that, provision selection list was also issued and final selection list was also issued. I have produced along with my reply statement. In the year 2016 itself, later on, they are not amended the petition, nor made the selected candidate also party to the proceeding.
What do you say?
Lordship, I am for the petitioner, Lordship. I have not yet served the objection copies.
2016 itself I filed.
Give him a copy, we'll have it next week.
Please.
He's saying it's become infructuous. Examine and make a submission. Learned counsel for the respondent submits petition has been rendered infructuous in light of subsequent developments. Copy of the additional pleadings filed to be served on counsel for the petitioner. Release the matter in the same stage on
14.
Please.
You give him a copy.
Please.
Yes, I have to take a picture.
My lords.
List serial number 21 and 20 are one and the same. Serial number 21 has stated that the on 16/10/2024.
My lord, sir, I have objection, my lord. It's not a similar. They have challenged with respect to pay, sixth pay commission. Ours is a regularization.
Not only the sixth pay
Serial number
commission, I
21, my
also
lord.
filed
I'm
for the
appearing for
litigant
petition.
Also, my lord. Same matter yesterday it was listed, my lord. I requested this honorable court to today, but it is not listed today, my lord. Yesterday's serial number 41 matter. Today it is not listed.
Serial
Both
number?
are one and the same, my lord.
Serial number 41 yesterday.
Yesterday's matter. That is
Date. Date Monday. Monday. That is listed on Monday.
this also may be listed in the
My lords, in serial number 20, my lords, in serial number 20, we are yet to file objections.
Serial number
20, my lords. You see, request matter may be taken up in the next week, my lords.
no, this may be listed on Monday, my lord.
No, let him come. No, just one minute. Let him complete. I'll give a date. No
Please.
further adjournment.
Please,
So when will you file?
my lords, by next week, my lords. Next
date.
Friday or Monday, it may be taken up.
Date.
13.
12th.
Please,
20,
Not 12th, my lord.
13th.
please.
20 list on 13th, 21 list on 13th,
21 is not a similar one.
21.
21 is not a similar. It is only covered by decision which we need to furnish
Okay,
and
so
they.
20 list on 13th. 13. Okay, what is 21?
This, I appear for petitioner, my lords. They need to make a submission on this, my lords, where it's a covered by decision what we have submitted last occasion, my lords.
It's covered by which decision?
My lords, by this honorable court, my lords.
Point out.
Pursuing, yes, ma'am.
My lords, this matter may be taken up in next week, my lords. Next week matter may be.
Let us see what they say.
Please.
Let us see what they say.
Please.
Covered by which decision?
Yes, my lords. May I take my lords, page number, my lords, my lords, annexure B, my lords. May I take my lords, annexure B?
Yes.
Annexure B, my lords, where it's an appointment order, where my lords, number 1 is Mr. Nagendra HG. And the second is a Kumari K.N. Narina.
Page?
Page number 21, ink page number 29. 29, ma'am. Ink page number 29, annexure B. It is an appointment order, my lords.
On contract basis.
Contract basis on, after the advertisement and going through the selection process. In 2005, where the university got established, my lords, in the year 2005 itself, my lords.
Yes.
Thereafter, my lords, the person who is one, my lords, Mr. Nagendra, he has filed a petition before this honorable court. That's my lords, annexure A, Z. 241, ink page number 241. He sought for a regularization, my lords, wherein, my lords, this honorable court my lords, allowed the petition. It's in a
What is the reasoning?
reason, my lords, last ink page number 253. What becomes unmistakably true is that the petitioners were appointed, page number 253,
Yes,
ink page number 253, running page 13
yes.
of the judgment. Last para. In term of aforesaid extracted paragraph of the statement of objection, what becomes unmistakably true is that the petitioners were appointed for smooth functioning of university against the vacant sanction post. Having appointed the petitioner and utilized their service to overcome the teaching problems of the university, as it newly established, cannot now turn around and say that they cannot consider case for a petitioner for regularization for their services. It is also to be noticed that every right that the required for a regular appointment was undertaken by the university while appointing the petitioners on contract basis. On this ground, my lords, petition may allowed, my lords. Subsequently, my lords, university preferred the writ appeal. That is next page, my lords. Annexure AZ2, ink page number 256, which came to be dismissed on the dismissed, my lords. Further, they have not preferred the appeal, my lords. So the person, my lords, Mr. Nagendra, he preferred the contempt before the Honorable this court, my lords, before the division bench. There, my lords, it has been dropped. Against that order, my lords, the petitioners challenged before the apex court in SLP, where in the last occasion, my lords, there also it came to be dismissed, directing to regularize them, my lords. Subsequently, university has made a review petition before the apex court, my lords. That came to be dismissed on 16/10/2024, my lords. Pursuance of that, my lords, now they have issued the appointment order, my lords. So we also, my lords, I am in the appointment order second number, my lords, Nalina, as I shown in the annexure B, my lords.
Lords, next week it may be taken.
No, that will say, but what is the purpose of adjourning? When the person appointed under the same order to the same process has been regularized, then they also on parity, same reasoning will hold good. Unless, what ground you have to say that we need not follow that?
My lords, madam appears, my lords. She's held up in another court. It may be taken up next week, my lords, Wednesday, Tuesday or Wednesday or Thursday, Friday, my lords.
No, why you're asking such long dates? If it's covered, there's nothing more to argue.
My lords, other matters are there.
Huh?
Other matters are there, my lords. My lords, if the regularization decision is taken, the university is not self-financed, my lords. It has to get approval from the state government as well. So there are more than 500 employees, my lords, who will seek a regularization.
So now we are only on the point of these four who are a subject matter of an order.
My lords, not four, my lords. In this
My
petition,
lords,
there are many petitions.
40 members are there, my lords. Wherein, my lords, there is already a 128 sanction poster available, my lords.
Then so far as those 3, 4 we'll consider immediately. Remaining we can see, we'll have to hear. We list them.
All, my lords.
No, we
now
have to hear.
yes, my lords. My concern is that, my lords, I am appointed in the same appointment order, my lords. If they were permitted with the appointment order, my seniority also has to be, my lords, they have to take concern.
That will take care of.
Yes, ma'am. If that is there, my
If
lords.
relief is being granted,
Yes, ma'am.
automatically consequential, how it is to be done, we'll see.
Yes, ma'am. Yes.
We'll list the matter on.
Only this issue is there, my lords. If they answer that.
Let us
it
see.
would-
That's one for so far as 3, 4, it is clear. The remaining
Yes,
we don't.
remaining also I have placed the appointment order, my lords, where the dates are there, my lords.
No, but that will require some hearing. Let's see. We'll list the matter on 14.
Shorter date, my lords, on 7th or 8th, my lords.
8.
Yes, ma'am.
ಯಾವತ್ತು ಅದು? ಇದೆ. Then all will have it on the same day. let
My
us see.
lords, My lords, they are the daily wages, my lords. They are not from the appointed through advertisement.
Advertise.
So their claim is that, my lords, we
Let us see,
we
let us
were
see.
extended with the
Let
pay
us-
scale, my lords.
Then we'll have it on 8th. We'll have
Yes,
this on
my
8th
lords.
and then we'll see what is to be.
Yes, my lords.
Lords, may I request for 9th, my lords?
9th.
Wednesday.
Maybe 11th. 11th. Yes.
Attend ಮಾಡಿ.
This case, R10 has to give some clarifications, my lord. Just seek a passover, my lord. R10 has to give some clarification.
No, it is not for R10, my lord. It is, why it was adjourned on last occasion is, my lord. Of course, Lieutenant Senior Counsel, Mr. Deelan Rao wanted to make some submissions. In the meanwhile, the lordship has directed the respondents to secure the government order, which is the, my lord, order by virtue of which the diploma in painting is sought to be declared as equivalent to the other courses. Unless that government order is placed, my lord, it will not.
Yes, government.
Sika, lord. Passover.
In fact, I had sought under Right to Information Act.
You have got it.
Kindly pass over, my lord. He's held up in 21.
So that is the, let him place that government order. Pass over, let us, you have it.
Yeah, have it.
Have it, pass over. Let us share it with the others also.
23. 23.
Week's time granted to take necessary steps.
Petition, my lord.
Lords, may I be permitted to file a memo, my lords, in support of this?
Regarding stop payment of the pension order, my lord.
No, now you have a look at it, whatever documents they're producing it. I'll have it next week.
Next
and
week.
then we'll take up the matter.
Yes, my lord.
Memo for production of documents filed by the government is taken on record. Relist the matter on
7.
7.
25. 10. 25.
Relist the matter on
14. 26. 56.
I appear for petitioner, my lords. My lords directed the respondent to approach the management to arrive a settlement. The respondent did not approach.
No,
We
no, no.
informed-
They have not called me, my lord. I was in fact eagerly waiting for a call from them because
Okay, just coordinate. Have
Please,
it
my
next
lords.
week.
Please, my lords. We
Just
informed-
coordinate.
Oh, please.
Now itself.
let them inform me whom I have to contact because, my lord.
Please,
No,
my-
that now you just sit, you inform them.
Please.
And then we'll have it in a date for it.
My lords, till then,
14.
my lords passed an order for not to precipitate the matter.
Taken
May
the
we kindly extend it?
execution matter, my lord, is going on. I have not taken any steps, my lord. Is still in the stage of notices.
Counsel for the respondent. Earlier direction to the respondent not to take precipitated steps in the execution proceedings is extended till the next date. Relist the matter on 14. Now you just intimate him,
Please,
just
ma'am.
sort it out.
Oblige.
47.
Respondent number 6.
Petitioner is a professor. Lord, the contesting respondent is the university. Lord, the dispute is as regards the appointment to the post of Dean, Faculty of Commerce. Lord, the challenge is to the impure notification at Annexure A, appointing the 6th respondent professor as Dean to the Faculty of Commerce instead of the petitioner. Lord, Section 21 of the Karnataka State Universities Act deals with appointment of Dean. Lord, the appointment is by way of seniority and rotation. Seniority coupled with rotation.
Who is the contesting respondent?
6th respondent.
Appear for respondent number
University as well as the 6th respondent professor.
You appear for
Respondent number 6, my lords. I have filed my objection on 24/10, my lords.
university has also filed.
University has also filed.
Filed. How much time you'll take?
5 minutes, my lord.
What is the point?
But the point is, under section 21 of the Karnataka State Universities Act, my lord, the appointment to the post of dean is by way of seniority coupled with rotation. May I read section 21?
Yes.
A professor in each faculty according to seniority shall by rotation act as a dean of faculty for a period of 2 years. Provided that if there is no professor, the senior-most reader shall act as dean. Provided further that if any faculty there is no professor or reader, then the vice chancellor may in his discretion designate, these do not apply to me, my lord. My lord, the professor, if professor is present in the faculty or in the department, he must act as dean by rotation and as well as seniority.
So how many professors are there?
My lord, in all, there were 4 professors in that faculty.
4.
4 professors.
So according to you, each person will get 2 years.
2 years.
Under
And
the
they shall act as dean on rotation. On rotation.
Terms of that principle.
Yes,
of
yes,
rotation.
yes. In principle of rotation. 6th respondent, my lord, he had already acted as dean. My lord, certain dates are relevant, my lord. My lord, on 3/7/2023, the petitioner, my lord, who was an associate professor, applied for promotion under the career advancement scheme before the board of appointment. 3/7/2023. My lord, on 13/7/2023, the board of appointment of the university recommended the petitioner to be promoted as professor with retrospective effect from 27/7/2023. With retrospective effect from 27/7/2023. But the office of dean, Faculty of Commerce, fell vacant on 2/3/2024. My lord, I was given the formal orders of promotion on 14/6/2024 based on recommendation of the board of appointment. 14/6/2024. My lord, the impugned notification appointing the 6th respondent instead of me came to be passed by the university on 24/6/2024.
What was the date of appointment of the dean?
My lord, it fell vacant on 2/3/2024. The impugned notification was passed on 24/6/2024, appointing 6th respondent instead of me. My lord, now the stand of the university is that as on the date of the office falling vacant, that is on 2/3/2024, I was not born into the cadre of professors, is the stand of the university. My lord, your lordship may kindly appreciate, on 13/7/2023, the board of appointment had recommended my promotion with retrospective effect from 27/7/2023. But university, with malafide intention, did not pass formal orders. Be that as it may, my lord, even on the date the impugned notification, that is 24/6/2024, he was not, the 6th respondent was not appointed as the dean. Even I was not appointed. But on 24/6/2024, I was already a professor. And the 6th respondent had acted as dean prior twice. So there is a clear violation of rule of rotation.
Continuously.
Continuously. Munche, he has acted.
No, when was he appointed dean earlier?
Earlier, twice he has acted as dean on different this thing.
Previous periods.
Previous periods. I had not acted as dean. This is the first time I was supposed to occupy the office of dean. My case is that, my lord, there is a clear violation of rule of rotation. Of course, he is senior. 6th respondent is senior, no doubt, senior to me. But he had already occupied the office of dean prior. And on the basis of rotation, my lord, I was supposed to occupy the office, is my case. And on the date of the impugned notification, that is 24/6/2024, I was already a professor with effect from 27/7/2023.
When are you retiring?
My lord, I have time, my lord.
He's still 44 years,
I
my
have
lord.
time.
He has got lot of,
I have
you would have
time.
3, 4 rotations.
Just wait.
I have time, my lord. No doubt about it.
So what we are saying is, of course, we'll consider it, but suppose the university were to take a stand that if we were to, after 2 years, if you are the most eligible amongst the other professors, if they were to take their stand and the government also takes a stand, then we can put a quietus. I'm
Correct,
just
my lord.
throwing it open.
Correct, correct.
I'm just throwing it open. We'll see what the university has to say as regards this. Then why make it bitter? Let it be sweet after 2 years. Now, if we were to, without entering into the merits, that's a different matter.
Yes.
Now, after 2 years, there is a prima facie, it appears there has to be a rotation,
Yes,
isn't it?
based on seniority. Seniority also counts.
Correct, correct. So if, according to you, in terms of the records available with you, he would be the most probably automatic choice subject to other contingencies. Then you get instructions, let us see. Then there is some kind of an assurance, there ends the matter.
Lord, as soon as he becomes professor, he wants to become a dean. That is a problem, my lord,
No,
in
as
these
of now,
particulars.
as of
Alala, or he was appointed only now, my lord, as a professor. So as on the date of vacancy, my lord, he was not a professor at all.
Not the.
So,
without
Hagagi, he would not get any eligibility as on the date.
correct. So without entering into the merits,
Yes, ma'am.
after 2 years,
Yes.
if after 2 years,
Yes.
and this rule is thought to be put into force, if he stands the best chance,
Yes.
subject to some riders, we can close it.
I'll just get instruction.
Get instruction. Really, let us see.
My lord, my this thing writ petition is on principle, my lord.
No,
Because
that
the
is
act
there.
of university
No,
malifiedly.
No doubt you have a case that we'll have to hear. But I'm saying if this could be, it could be worked out like this, you get
But
inspection.
in fact, this honorable court in MS Talwar's case has held, university gets no jurisdiction to appoint somebody as a dean. It is the professor who has to act as dean on seniority by way of rotation.
Correct. Now, we can hear it. I'm not saying no.
Yes, my lord, let him take his
Let us
instructions.
see.
Let a short date be
Ah,
fixed.
So there ends the matter. In case something positive comes, let us see. Relist the matter. The same stage. Yeah. Because if we issue rule, then 2 years will fly away.
Already 6 months have elapsed.
Let us, yes.
ಯಾವ್ದು?
Petitioner, my lord.
Date ಯಾವಾಗ?
Date Kumar, 7.
My lords, petitioner is clerk cum computer operator at second respondent Panchayat office, my lords. My submission is this, my lords. I was given a show cause notice.
Now, who appears for the chief executive officer?
I am appear for Gram Panchayat.
Hmm.
I am the contesting respondent.
Contesting respondent.
No, correct, but who
In the
appears-
previous round of litigation also,
Hmm.
only 2 and 3 was contested.
It's a
Contesting
case
respondent.
of suspension, my lord.
Yes, my lords.
Who passes the order?
The order of suspension. Now
Was
inquiry,
passed by respondent number 2, my
now
lords.
inquiry has initiated.
Initiative.
Charge memo has been issued. She did not reply to the charge memo.
No, my lords, we have appeared.
Appointed
all-
inquiry officer. Now to date, inquiry has already completed to date of hearing. Now it is pendency, my lord, inquiry. At
My
that
lords.
time, my lord, it is
My lords, my submission is this.
32.
A show cause notice was issued to me, my lords, on certain allegations for which I asked to show cause why I should not, why disciplinary actions has not to be initiated against me, my lords. For such particular allegations, I had given my representation or reply, my lords. But in the impugned order at Annexure H, my lords may kindly see Annexure H at
No, just 1 minute. Now, when is the order of suspension passed?
my lords on 3, my lords, on 3/2/24.
3/2/24.
This is second round of litigation.
No, just 1 minute. Now, what has happened to the order of suspension?
The
Now,
first
Inquiry has started.
started.
So
Three,
you reconsider that order.
because he is the Gram Panchayat employee, my lord. Till the inquiry proceedings is completed, he cannot be revoked. He can be continued in Gram Panchayat only.
What does the rule say?
Rules, my lord, insofar as rules is, my lord, 2020 rules.
So for a order of suspension, what happens? What is the
If the inquiry has been initiated, my lord,
Order itself is void, my lords.
we have paid the subsistence allowance to the petitioner during the period of
What is the allegation?
allegation, my lord, unauthorized absence, as well as, my lord, for non-implementation of the scheme in the Gram Panchayat, my lord. Therefore, the entire,
What is the purpose of keeping under suspension? Why you want to pay subsistence allowance? Get work from him done. If it is of unauthorized absence and not implementing certain direction, that inquiry you are going to do. Now charge is issued. Get work from him, pay him. That's all. Why you want to allow him to sit at home and pay? He can't interfere and do anything now because your articles of charges have been issued. Inquiry has started. Put him on terms and revoke the suspension order. I'll have it next week.
please, I have to get the
Without entering
instruction.
into merits,
Please,
no purpose will be served by keeping him under suspension at this stage,
please,
isn't it?
please.
So let the inquiry go on. We'll subject him to terms. And then let it go on. You extract work from him, let him be paid.
Please, my lords.
Relist the matter on.
Please.
Grateful.
It takes time in this matter, my lord. I'm yet to receive instructions. Serial number 29.
29.
Relist the matter on.
My lord,
Please help me.
kindly give a date, my lord. Kindly have it in orders, my lord.
14, same stage. Let
My
us
lord, my lord, on submission, my lord. Kindly have it in orders, my lord.
same list. It has reached by 11:30. Next.
30.
Grateful.
You must be.
Lord, this is being respondent, my lord. Kindly pass over. I'll up the another court, my lord. 2 minutes, my lord.
What is this matter?
My lord, transfer matter, my lord, on the other day, your lordship suggested that he said that the transfer is done pursuant to complaint filed by Dalita Sanghrsha Samiti. And I said that it is, they treat it as a stigma. And thereafter, my lord, your lordship suggested that stigma, I'll say that stigma cannot be attached to that. Now, my lord, I just made an inquiry with my client. My lord, she is not convinced for that also. She says that complaint itself is frivolous. Therefore, I given reply.
Let us see. Pass.
My lord, instead of passover, may I seek a request for Monday, my lord. The reason is afternoon I have some personal inconvenience.
Next week. No.
Monday, my lord.
No, let us see. Now let it take its own course. I'm not going to expedite here.
7.
7.
But if you don't report, I'm going to take a strict view on the matter. Yes.
My lord, I am on the sick leave.
I don't know. That is a different matter.
Appearing for respondent, my lord. Kindly pass over, my lord. 2 minutes, my
My
lord.
lords, appearing for the petitioner. My lords,
So,
31, I appear for the petitioner, my lords. In this, I'm challenging the order of entrustment.
correct. They are seeking for a passover.
31.
31. Yes, my lord. Kindly pass over.
This is the second time
2
they're
minutes.
seeking for passover.
2
For
minutes,
the
my lord.
purpose
Held
of
up the
interim
another
order,
court, my lord.
matter is
2
covered,
minutes.
my lords. Your lordship's
Held up the
order.
another court, my lord. Senior.
Passover. Let us,
Lords, may I request it may be taken at 2:30, my lords. There is some urgency.
let us see. Passover.
32. Great. 32.
For the respondent, tourism instruction will be taken up in the second week of November, my lords. It's with regard to termination.
This is the matter in the second, relist on. Yes.
33.
For petitioner, your honor, my lord. Yesterday, your lordship had a observation telling that what has been dismissed from service, reconsider together both of you, whether we can place him under pending inquiry, can we do it? Like that, you think? I have a small submission to make in this honor, because I, being a responsible officer of this court, there are some settled positional law and some decided cases. You kindly permit, I'll read it. 3 citations are there, your honor.
If you're going to argue,
Yes,
it will come up in due course. Let us. That's your risk. I'm not going to take it up out of turn, let it, it will take its own course. Let us.
Interim prayer may be considered, my lord. Because mother and son have been pushed on the road for no
I'm
fault of
giving
theirs.
you the best relief. If you don't want to take,
No,
then it
and-
requires hearing, that's all. We'll hear it. We can't, now, if you are terminated, I'm telling you, what is the relief you're going to get finally? Relief you're going to get is for redoing of the inquiry. Inquiry must be held once it is started. Now, their allegation is that you were given an opportunity, you didn't participate. According to you, they have not given full opportunity. So what is the relief you are going to get? That the inquiry, we can't set aside the inquiry. That's a matter which involves a factual, so the inquiry will have to go on. And you have to be given an opportunity because you have to put forth your case, isn't it? So what is the relief you're going to get finally? That the inquiry is reopened, your best relief is inquiry is reopened, you are given an opportunity. I'm giving you that opportunity now itself. If you don't want to take, then it will come, we'll hear the matter, that's all. It's up to you, I'm not forcing you. But I'm asking you, what is the relief you're going to get finally? Suppose a petition is allowed. Inquiry will be set aside and liberty will be given to them to reinitiate. We can't say inquiry is quashed, there ends the matter. Because you are saying that there's violation of principles of natural justice. That relief we are giving it to you now.
Can I make a small submission,
Yes.
my lord? Lot of damages has been done. Irreparable damages have been done. One is terminated without notice or notice pay. Second is they are not allowed to take a co-employee.
That all that I'm going to observe now.
And now, when I go around with this, all the damages they've done, they'll redo it because every points have been made to them clear.
Let us see. Let it come up, we'll see.
And moreover, the action they're taken under.
Unreasonable.
Okay, oh, much, sorry.
You're being very unreasonable. When you're getting relief, it is a via media. It's like mediation. Arbitration and court is, you'll go and get whatever you're entitled in law. We in the interregnum are proposing something that is acceptable to both. When it's acceptable to both, you will have to give up something. They will also have to give up something. It's a via media in which both of you can get some benefit. If you want that, that we have to decide as per law, it will take its own course. We can see.
Maybe consider for day-to-day hearing, Your Honor, my lord.
I am not going to take any matter day-to-day. You are in the queue, just as many others are in the queue. Okay, let us see. We'll hear the matter. If I were to reject your interim prayer, there ends the matter. You will come back after 5 years. That's your headache.
One submission.
Yes.
My lord, one submission. They have issued the articles of charges under the Karnataka Education Act 1983, my lord. That enactment is not applies to the petitioner, because he comes under the Directorate of Sanskrit.
So you want me to go into the merits? We'll go it. I'll take it up in due course, no interim order. That's all. We'll see. Let it come. Let them file their objections. I'll consider. That's. And I'll make it clear that if they suffer an order, obviously they're going to pay back wages. That would be a benefit. If you're ready for that, let it come in big group. We'll hear it. Let them take their pleadings. I'll make it clear that if you were to succeed, they will have to pay back wages. That will take care of your interest of loss of emoluments in the interregnum.
Yes. Much of it.
So then you take your stand in writing.
Yes.
If apart from what you have stated, if there's any further contention, you take it up. Let it come in due course. We'll hear. The only condition is that in the event they succeed, then appropriate back wages.
But he may be kept under suspension, my lord.
No, I'm not granting any interim order. They want the matter to be heard on its merits.
Yes.
Statement of objections to be filed by anything else you want to file, or that's all?
I have already filed, my lord.
That's all.
I have already
I
filed and I have produced
have-
all the annexures also.
I
And
have-
the university has to file, my lord.
I have to file 3 and 4, respondent number
I
3.
will have to serve the copy to university. I will, today only I will serve it.
R5 have filed their statement of objections. University to file their statement of objections as well. Counsel for the petitioner has advanced certain legal submissions which requires to be met by the other side as well. While counsel for the petitioner submits that no sufficient opportunity has been granted, counsel for the respondent submits that opportunity granted has not been utilized. Once the university takes its stand in writing, the the contentions of the respondents would also be clear. Relist the matter. When will you file by? When will you file by?
2 weeks.
Date would be 22nd.
22nd. Much obliged, my lord.
Petitioner challenged the transfer order. Annexure F. To kindly appreciate the petitioner working woman head constable under the 5th respondent. Or kindly appreciate petitioner son is studying in the 12th standard. Therefore, she made a representation under Annexure C, October 2023 for exemption to annual transfer for the academic year of 2024 and 25, as his son is appearing for the 12th standard final board examination. Now, Lordship, without considering the petitioner respects.
You're working in Bangalore since
2016, Lordship.
So what is the tenure normally?
Normal tenure is 12 years, Lordship.
12 years
12 years.
at each station.
Each station, that means after completion of the out of station, in hometown, she has entitled to do duty in 12 years. Now, Lordship.
Take me to that, let's see, rule.
Prior to that, Lordship, page number 24. 24, class 26, I will read out, Lordship. Extension of tenure on education ground. NGO will be permitted an extension in his or present until for 1 year if his or ward is studying in 10th or 12th class in the current academic year and studying with him at the place of posting. He will not be given extension.
Page?
That's it.
Page
Number 24. Class 26. Annexure A, transfer guideline.
Three years in a unit, class 25.
Class 25, not class 26 is our applicable for extension of tenure. Extension of tenure
by 1 year.
1 year.
1
Just
year.
we want to asking only 1 year on the ground of ward education.
Your child is studying?
Studying in 12th standard. CBSE syllabus in Bangalore. Now, your Lordship, kindly appreciate the petitioner husband also working in the same department. He has been already transferred to the Jajguda, Jharkhand. He is only look after the petitioner, her son education. On that ground, he made a representation October 2023 itself for exemption of the inter-unit transfer.
Yes. What do you say?
My lord, my first submission is this, my lord. About 408 personals have been transferred. It is not only the petitioner who is transferred. First submission, my lord. And my lord, the husband and wife, both are transferred to the same place.
Same. place.
Same place. And my lord, 1 year extension is already been given to 10th standard.
Not petitioner son. It's husband. Her husband ಗೆ 1 year has been.
ಹಸ್ಬೆಂಡ್ ಒಂದ್ ವರ್ಷ, ಮಗು ಹೆಂಡತಿಗೆ ಒಂದ್ ವರ್ಷ ಕೊಡಕ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಮಕ್ಕಳು
It is only for the child.
two childs ಅಲ್ಲ. Son and daughters.
No, just tell me that previous extension just point.
Please, my lord, I'll put it on record, my lord. Otherwise, I'll put it on record. And my lord, my learned friend does
Still
not.
to file.
I'm yet to file. I'll file it. My lord, the question of filing may not arise. The reason is this, my lord. Your lordship may kindly see. Sir.
Kudu.
Sir. She intends to resign from 2031-1-2025. Advance retirement, which is unheard of. However, my lord, if she wants to go from 31-1-2025, let her file an affidavit. We will not disturb her.
Which was made subsequently when she was the authority have not considered the representation. Having no other alternative, she made a.
Correct. If you file an affidavit, there ends the matter.
No, your lordship kindly appreciate. Since filing of the early retirement application, they did not consider, even though
Correct.
they are forcing to.
Nobody is forcing you. Nobody is forcing you. You want to take, you take it. If you have given a letter that you need to, that you intend to take voluntary retirement, they're ready to accept it. There ends the matter.
That is different lordship because she is eligible under the entitled under the article class 26.
Entitlement is only a consideration,
kindly appreciate
not as a matter of right.
When the authority did not consider the
Yes,
request.
you place it on record. Place your stand.
I have made a annex also. Lordship.
Let us see. Let them put it in writing.
Even otherwise, my lord, even otherwise, there's a guideline says, notwithstanding the guidelines contained in the circular, any personnel may be posted anywhere at any stage. Page 30. Page 30, clause 20. Clause 20, my lord, notwithstanding, your lordship got it, my lord? Notwithstanding the guidelines contained in this circular, any person may be posted anywhere at any stage by the competent authority without assigning any reasons, and the guidelines shall not come in the way of such transfer or post.
Now the husband has got the benefit of previous extension.
Previous extension.
Last year.
Last year.
That's it.
And my lord, it's a couple transfer. My lord, we don't intend to transfer husband one side and couple one side. I have the records, my lord. Both of them are transferred to the same place. Initially 10th standard they've taken. Now it is the 12th standard. Of course, my lord, I do understand, my lord. I don't want to make a mess out of it. My lord, now since she is given a voluntary retirement, my lord, it's become an habit that they give voluntary retirement saying that 31-1-2025 and withdraw it on that day or one day previous to that. This is the modus operandi of this letter.
So what do you say? You take your file an affidavit regarding. File your affidavit.
That's
counsel for the learned counsel.
On the other hand,
no, you file an affidavit regarding this. If this is your stand, there you can't have two legs in two boards. You either, if you don't want to take this, you make it clear. We'll take up the matter on merits.
Till then, I actually sees in a medical leave. Till then,
no, you take an affidavit, you file an affidavit, then we'll see. The DSG has filed.
Type copy of it.
Along with memo, an application dated 4/10/2024, which would indicate that the petitioner seeks.
The typed copy I've given it, madam.
Seeks voluntary retirement. Petitioner to file affidavit regarding the same in light of the stand of the respondent that if application for voluntary retirement is filed, the present petition does not call for any further adjudication.
Please.
Necessary affidavit to be filed by the next date. Relist the matter on. When do you want it?
4th.
4th.
Great.
transfers, you will have to go with the employer. You can't make it a absolute right.
undergone
You can't help it.
surgery also.
No, that may be so. It is the employer's prerogative.
No, regarding what's education, sir?
No, you want to resign, you resign it, that's all. That's up to you. We will not force, but you are an employee. And all employees must know that they have to work in the establishment. Yes, next.
Great.
Okay, petition. Herein petitioner seeking for the quashing of annexure P passed by the response number 3 CEO, not to consider in par with their own scheme of 2002 scheme and 2005 scheme in implemented in HS Raghupathi case, and also the latest passing up the order of this coordinate bench order in annexure Q, regularization of the daily wage employees who have appointed on 1784.
Annexure?
Annexure P is the endorsement. Annexure Q is this honorable court passed in this recent order in page number 168.
Same corporation.
Same. The same stand of the petitioners.
Yeah, they'll have to file their statement to this. That is sericulture.
But they are the employees of the ZP. Sericulture and number of departments are comes under the same category.
You know, let them take the stand.
Please, Mela.
Let them take their stand.
One office objection is there. The ML ಕೇಸರಿ ಹೇಳಿ ಬರೆಯೋ ಬದಲು ಬೇರೆ ಏನೋ typographical mistake ಇದೆ ಅದನ್ನ ಇಲ್ಲಿ correct ಮಾಡಿ. Prayer.
Office objections to be complied with by the next date. AG is directed to accept notice for respondent 1, 2. Then engineer Panchayat Raj, separate council or you can take?
It comes under the
Separate
ZP.
council. Jilla Panchayat Shimoga. A. Nagarajappa is directed to accept notice for respondent 3 to 5. List week after next.
Let me kindly consider particular date.
Date.
Please, ma'am.
36. Yes, ma'am, for the petitioner.
May I just request to come to the annexure D at page number 15.
What is the office objection?
Office objection has raised that I have not stated about the annexure D in the prayer as well as in the interim prayer. In fact, I have not challenged that annexure. That's why I'm requesting to come to the court at page 15.
Page?
15. Annexure D. The petitioner promoted from the post of assistant professor to professor by this order on 30/8/2024 with 6 AICT pay scale.
Yes.
But no salary has been released in favor of the petitioner. That is why I'm seeking an direction from this honorable court to release the salary in accordance with this order.
AG is directed to accept notice for the first respondent. Is there any standing counsel for
Mr.
2 and
Nitish. Nishant.
Counsel
For 2 and 3.
AV Nishant is directed to accept notice for respondent 2 and 3. You serve copies today.
Please.
The matter in the orders list on 7th.
Much.
Seven.
Just one. An office objection. Office objection is kept in abeyance for the present.
Notes this review petition, my lords, is filed, my lords. Pursuant to the order passed by the Honorable Division Bench, my lord, reserving liberty to file a review petition. Lord's order under review, my lords, is at page 16, my lords, annexure A, my lord.
Annexure?
A, my lords, at page 16. In fact, on the last date of hearing, my lords, the papers pertaining to writ petition, my lords, which was disposed of, my lord, was ordered to be put up by this honorable court.
Orders annexure A.
Manoj, please, Manoj, in the writ petition which is under, sought to be reviewed, Manoj, dated 23rd of August 2018, Manoj, is the order, Manoj.
Amount of 4 lakhs has been admitted.
Manoj, it is admitted that is pending consideration, Manoj, in a separate proceedings. RFA is pending, Manoj, which is filed by the institution. The amount, the quantified amount, Manoj, which is liable to be paid in favor of the petitioner herein, Manoj. That, Manoj, there is an order of the EAT, Manoj, tribunal to pay back wages in favor of the petitioner. The quantification was done, Manoj, in the execution proceedings, which was initiated, which was filed by the petitioner herein, Manoj. Challenging that quantification, Manoj, the respondent number 5 to 7, Manoj, institution has filed RFA, Manoj, and the same is pending consideration, Manoj, before this honorable court. The honorable single judge, Manoj, in the writ petition, the order under challenge, Manoj, was dated 6/4/2010, Manoj, which was passed by the respondent government, rejecting the claim of the petitioner, Manoj, to treat the entire period, Manoj, as duty. In fact, that period, Manoj, from 1991, Manoj, to 2000, till the year 2000, Manoj, I was not permitted to work, Manoj, by the institution, respondent number 5 to 7 institution. That entire period, Manoj, I requested the respondent government, Manoj.
What is the direction by the division bench?
Manoj, if your lordship peruses page 21, Manoj. The order of the honorable division bench, Manoj. Para 2, Manoj. Learned counsel for the appellant submits that the challenge in the writ petition was made to the order dated 6/4/2010 passed by the Deputy Director Public Instructions, the validity of which has not been
So now you have served copies, is it?
Manoj, I have served copies, Manoj.
On the other council?
Manoj, they have also filed their objections. The institution, Manoj, has filed objections.
5 to 7.
Please.
So let's see.
HK Ravi, Manoj, appears for.
We'll give another date and we'll hear.
Please.
Relist the matter on 8.
Great.
There are 3 IAs plot for to bring LRs of the deceased respondent number 1 and for setting aside abatement and also to condone the delay, my lord.
Who has died?
R1, my lord. R1, who was a second division clerk, was entitled for reinstatement as well as arrears of salary from 1989, and he got superannuation on 30/4/2013. So now the petitioners are entitled to, they are liable to pay the salary to the LRs, my lord.
So we'll allow these applications. We'll allow the application.
Very well.
Good. Again, office objection. Deviation, no deviation. Huh? You have filed wakalat of the applicants.
Wakalat of the applicants. I have
You have filed.
Yes.
It is submitted by counsel for the applicants that the respondent number 1
minute
died on 10/7/2018. And you filed the application with delay, is it?
There is a delay, my lord. On 3/2/2020, I came to know about his passing of the order.
And the relief sought for in the main proceedings survives on the legal representative. In light of the same, IA 1/23 has been filed seeking condonation of delay in filing the application to bring LRs on record. 2/23 for setting aside abatement, and 1/20 for bringing LRs of the deceased R1 on record. In light of the governments made, applications are allowed. IA1 of 23 is allowed. Delay in filing application to bring LRs on record is condoned. Abatement is set aside. Accordingly, IA2 of 23 is allowed. IA1 of 20 is allowed. And the LRs of R1 are permitted to come on record and represent the interest of the deceased respondent. Necessary amendment to be carried out. Very well. Relist the matter. Date
12th of November.
12th.
Appearing for petitioner, mother. Petitioner was died on 2/1/2021. And IA for bringing LRs.
Who died? Who died?
Petitioner. ma'am.
Petitioner.
Yes.
Will allow. Same order. Same order. Necessary amendment to be carried out.
Yes.
The petitioner has died, isn't it?
Please.
The counsel for the petitioner submits that the petitioner died on
2nd of January 2021.
2/1/21.
21.
2/1/21. And that the applicants are the
Wife and son.
wife and son of the deceased petitioner.
Yes.
It is submitted that the right to sue survives upon the legal representatives. Same one. Relist on. Carry out amendment to the cost type.
Yes. Bless.
My lord, in this case, the given judgment is today itself, have to.
May make one submission in this matter. Here is a case where, my lord, that all these petitioners are retired employees are claiming the pension. Now, the coordinate bench of this court, my lord, has already allowed the one batch of the petition where, my lord, that the state government is, my lord, is now taken steps for implementation. It has reached, now they have not challenged that order also. No, my lord, similarly placed employees, this matter also could be disturbed on the same line. Let the state government take a decision in the matter.
Where is that other order?
But I have produced the order passed by the, along with the memo. And I also produced, my lord, the order in WP number 15,599 of 2024 annexure R, page 264, in the second case. In WP number, my lord, 15,599 of 2024. Annexure R.
40.2. You have filed a memo, is it?
I also filed
memo.
Along with the memo also, I filed it. Your Lordship, kindly see, my lord, the order passed by page 264. And annexure R, my lord, I also produced in the repetition.
Employees of the same.
Yes, ma'am. Lord, your Lordship, kindly see the operative portion of the order.
So they are
Paragraph
employees.
17.
Employees of.
My lord, they are working, my lord, as holding different posts in Karnataka Dairy Development Corporation. All of them will appoint.
KMF.
Yes. My lord, they were ultimately, but they have merged. When the KDDC was merged into KMF, my lord, they were continued into service. They retired from service. As regards the KDDC employees are concerned, my lord, the 2 employees, they have granted the pension. I also produced that order. And at the same time, another 2 employees, my lord, since the earlier, my lord, they have approached the Karnataka State Administrative Tribunal. My lord, that was allowed. Then, my lord, they have rejected it. Twice they have approached the tribunal, my lord. Finally, my lord, they have approached this honorable court. This honorable court has directed the state government to grant pension to them also. Then they went to the Supreme Court also dismissed the SLP filed by the state. I've also produced that order also, my lord. But now, my lord, what they're referring is, my lord, now the division bench, my lord, has took a different view, saying that in some other matter, my lord, they are not at the Karnataka Silk Industries Development Corporation case.
Even that judgment also has been considered by the learned single judge in this, my lord, this honorable coordinate bench. In this order, in this petition, in this order also, my lord, your lordship may kindly see, my lord.
Now KDDC is the Karnataka
Dairy
Dairy.
Development Corporation.
Huh.
Corporation.
Now you are working originally.
My lord, my lord, what had happened was, my lord, there are three sets of employees, my lord, working in the KMF. One is, my lord, that the employees, they were appointed by the state government, dairy, Karnataka Dairy, government dairy. Then, my lord, the Karnataka Dairy Development Corporation. And the employee directly appointed by, my lord, the Karnataka KMF. Now, my lord, the employee is appointed by the government, Karnataka government, the government dairy is concerned. They have been sanctioned with the pension. But Dairy Development Corporation is concerned, my lord. Some of them, my lord, that I also produced the order where the pension has been sanctioned. Whereas in our case, my lord, that though there is now, my lord, my only submission is this, my lord. Now the coordinate bench of this honorable court has passed an order. Now, my lord, the time-bound direction also has been, they have not filed any appeal as against that order. Now the matter is, I was told it is now before the finance department, it has been cleared from all other departments also. Now let them consider these cases along with them also, man. That's my respectful submission. Because now what they are referring is the division bench judgment. That judgment has already considered by the, my lord, the coordinate bench of this court in this matter, in earlier batch of the cases. Now your lordship may kindly see, my lord. I have also produced the order passed by this paragraph. Page 292, my lord. Para 13. The learned advocate, additional advocate general sought place reliance on the judgment rendered by the division bench in WP number so and so, disposed of on 22/4 to contend that the claim of the petitioner will be untenable. It has to be stated here that in WP number so and so, the division bench was considered the situation where the petitioners herein had been appointed by the Karnataka Silk Industries Corporation, had been opted to govern by the Karnataka Silk Industries Corporation rules, and had chosen not to govern by the rules applicable to the government servant. However, in this case, they as noticed above, in respect of the employees of the KDDC, all the rules applicable to the government servants were expressly made applicable by way of a circular, and thereafter reliance placed on these decision referred to above would be of no avail. In my view, as with regard to the fact, sorry.
Just one. Just one factual clarification. Now petitioners are also employees of KDDC.
Yes.
Also KDDC.
Also employees of the KDDC one.
Yes.
Now your lordship may kindly see the operative portion of the order passed by the single judge of this court, paragraph 17, my lord.
Yes.
In the light of the fact that the KMF has already provided the sanction of pension to the employees who had earlier taken benefit of the provident, it would be necessary to direct the state government to apply the same principle and pay the pension to the petitioner after deducting the provident fund and other benefits, as been done in the cases of 7 other employees under the government order dated 26/5/2015. The 4 months time is granted to the state government to comply with this order. However, it is made it clear petitioner required to pay any other further sums apart from the sums they have already received as provident fund in order to entitle them the pension. The same shall be paid to them for adjusting the provident fund that has already been paid against the arrears of pension.
Yes, what do you say?
My lord, in this case, reply is filed. But if it is the 3 cadre of the appointment of the petitioners, once is private. Since the KMF is in 1974.
No, what do you say regarding the coordinate bench, judgment of the coordinate bench?
Please see my objection filed by the page number 8, para number 29, my lord.
This single judge's order you have challenged, is it?
Yes, my lord.
No.
Actually, additional advocate general is handled by the Honorable. It is clarity, the 29 page number, you see.
If she's coming, you tell us.
Yes,
If you are arguing, you tell us.
Argue, after that you have to clarify the
No,
page
come.
number 29.
I'm asking, you are saying additional advocate general is going to come. She's
Yes,
going to
madam.
come, I'll pass over. You must tell me correctly. If you are going to argue, you argue. If you say that she is going to argue, let her argue.
Even in the earlier, I'm sorry. I'm sorry.
Give one date. Next week one date.
So next week you bring her, otherwise you argue.
Yes.
They are claiming that they have to be treated on par with the employees as in the, as per the order in 33347 of 2019. You have to take a specific stand.
Yes.
Now, once there's a order of the coordinate bench, we cannot reopen that issue considered by the coordinate bench by way of re-entering into the correctness of that by looking into your objection. If they are employees of the KDDC, unless there is some reason to distinguish the petitioners from these people, it will have, benefit will have to be extended.
KTDC is a, some employee is the private KTDC. The some employee is the appointment of this government. The government employee have to take on the benefit of the.
Now,
That
who
is
are
the contrary of this case, man.
Who are the then no, if you are bringing your additional AG, you bring.
Yes, madam. Next week.
Let us see, let them do it.
Please.
Relist the matter on 7. Now, according to you, one is those appointed by the government have already been extended the benefit.
Yes.
Now, those who were working in KDDC have also been extended benefit by
Some
what?
of the employees. Some of the employees,
Right.
they have been extended. The two of them, my lord, earlier they have approached the Karnataka State Administrative Tribunal. They were appointed, my lord, earlier when they were working in government dairy, they have resigned. Thereafter, after establishment of Karnataka Dairy Development Corporation, they were appointed as a fresher. My lord, they have been sanctioned with the pen. I mean, my lord, when that was turned down by the government, my lord, this honorable court has allowed the petition and matter went up to Apex Court. Apex Court has confirmed the order passed by the division bench of this court. Now, that matter is also before the government for implementation, my lord. Since it has not been implemented, contempt petition was also filed. Now, what had happened, what my learned friend is saying that, my lord. Now, I too agree with my learned friend saying that, my lord, some of the state government also, my lord, has taken some recruitment and they have been deputed to the, my lord, that the KDDC. But those employees also have been paid with the pension.
That is, relist the matter in the same stage on 7th, 8th. You appear for?
Second.
Came.
Again, my lord, we don't have any objections, my lord. Only if the state government take a stand that yes, pension has to be given, then whatever the benefit we have given to them, which without dispute they have taken, that has to be returned because they will
No,
not
that-
be.
No, that that is the same condition
Please,
imposed by
madam.
the
That
coordinate
has
bench.
already been taken.
Ah, that-
My lord, the second respondent, my lord, that has already been, my lord, taken care of by this honorable court. What my lord
Please,
has said.
just
So,
take on.
They are agreeable for that.
Please.
They are agreeable, they want the same benefit. Let's see what stand is.
please.
Not appear for the responding.
Sir, this is a matter, my lord, His lordships heard us yesterday.
This is not regarding yesterday's matter.
If I may
Lord,
just
why
point
is-
out one clause before learned senior submits, my lords.
Huh?
So you make submission, just seeking court's
I-
permission.
I will clarify it, my lord, regarding the seniority. My lord, we have, after the disposal of the writ petition by the learned single judge, my lord, we have prepared a combined seniority list of the professors, my lord, in the BMC, which has been now challenged by the petitioner before this honorable court. We are not allowed, my lord, to finalize seniority at least as per the order of the learned single judge. Whereas, my lord, again, my lord, that order of the learned single judge is in writ appeal before the division bench. And in that, my lord, an order has been passed, my lord, all eligible persons can be applied. Before yesterday, my lord, an order has been passed wherein, my lord, petitioner has said, my lord, that though he is eligible to apply for the post, my lord, for the selection to the dean and director, he is unable to apply it because his name is not found in the seniority list of now prepared, my lord, draft seniority list. Yesterday, an order has been passed, my lord, to apply subject to result of the appeal. Similarly, my lord, here is also, my lord, the draft seniority list has been challenged by in this writ petition by the petitioner. With the result, my lord, we are unable to take a final decision, my lord, on that. And this decision, my lord, the seniority list, my lord, draft seniority list has been prepared as per the NMC regulations.
No minutes. It is not.
And
so.
my lord, for the last 1.5 years, my lord, we are not able to, my lord, appoint a regular dean and director to the institution. Only, my lord, temporary arrangements have been made.
This can be
Now, my
solved.
lord, petitioner can also, my lord, if he is also eligible, my lord, he can also apply. And ultimately, we will shortlist it, my lord, to 10 persons. If they are agreed, my lord, to the 10 persons, at that time, my lord, they can challenge it. Why they, my lord, they stop, my lord, the selection of a director and a dean, which is vacant, my lord, for the last 1.5 years.
Let's have a look at the division bench order.
Yesterday it was passed. Let's make a, what happened was, matter was mentioned at 1:30. The court said they did not have time at 2:30. Court said all that the appellant is asking, allow me to file application. To that limited extent, court said, anybody, whoever wants to file application, file application. They said subject to result of writ appeal. Also, it said subject to what learned single judge says. I'm passing on the yesterday's daily ordinance. It is not the case that is made out, that everybody, whoever is eligible. In fact, I ask a question to learned senior, who are the eligible people? They don't have a list who are eligible. There are 400 people waiting for appointment. Who are the 10 most senior persons?
But then now, where are we? We are neither here nor there.
Let's, if your lordships.
No, if the writ appeal is decided, then it changes the entirety of.
No,
If the single judge's order is set aside, what happens?
No, as on today, Milords, I'm mindful of the fact that his writ appeal is pending. If your lordship were to see, Milords, earlier order, Milords, interim order was not granted for the stay of single judge's order after hearing both the parties at length, Milords. Appellant was heard. In fact, Milords, Justice Aradhya was able. Both sides were heard at length, and then it was not stayed, Milords, and it only order was passed subject to result of appeal. Now, Milords, I may only point out, Milords, I'm not saying that something should happen contrary, Milords. Yesterday, Milords, bylaws were pointed out saying that they have done as per the bylaws, Milords. Now, Milords, bylaws themselves, Milords, at regulation 8 in the.
You ask clarification.
No, Milords, in fact, yesterday, yesterday's submission was made, Milord, that let the process go on. That is, Milords, categorical observations made by the division bench that it is made clear that permission to make an application is subject to the orders to be passed by the learned single judge in WP 5941. This was precisely in answer, Milords, to the request of the learned counsel, Milords, now who is here, who sought a categorical direction, Milords, let the process go on. The court said, Milords, we are only saying that let the appellant apply. If he is eligible, it will be gone. But may I, Milords, just make one submission, Milords?
Hear the matter.
It has to be heard,
Also,
Milords.
Milord,
We'll hear the matter, you keep it on.
yes, Milord.
You keep it on hold.
Yes, Milords.
Let Milord, process of Milord, filing applications may go on,
No,
Milord.
there's no point.
Because Milord, your lordship, they are
No point. Now, suppose you select somebody.
petitioners are also before the.
Unless there's a decision in this matter of who is eligible, there's no purpose of going on with your advertising. One, whether if it's going to be in terms of the fresh rules.
Kindly see, Milord, prayer
No,
mechanism.
we'll hear it. We'll hear it. No, we'll hear the matter, but not in the order stage. I'll fix the date.
One submission. There's one submission, Milord, your lordship kindly see. The prayer, first prayer, Milord, may kindly be seen in the writ petition. Set aside the provisional seniority list eligible professors, permanent appointment of post of director and dean. This is the first prayer. Second, direct the first respondent to issue a writ of mandamus to prepare the combined seniority list. That's what, Milord, because of this writ petition, Milord, we are unable to prepare a combined seniority list.
It's what stops them from preparing, Milords.
Why, Milord, if, Milord,
No, is there a stay?
No, Milords, it was said that subject to result of result petition, appointments shall be made, Milords, at the stage.
there is no stay order, Milord.
No, Milords, what has happened now,
And in the
that's all, Milords. If that solves the problem,
No, then you prepare the seniority list.
combined seniority list,
You
Milords.
prepare the seniority.
In terms of NMC, Milords, clause 3.10, which I read out to your lordships. In fact, that also is a requirement under the bylaws now, Milords, relied. Yesterday, only clause 12 was read out. Under clause 8, there is a clear, if I may rely, my lords, if I may just permit to read, my lords, clause 8 of the bylaws, my lords, which they themselves have produced. It says appointments have to be made as per this one, my lords. Para 8 or clause 8, my lords. It says, if I'm clause bylaws, my lord, in the statement of objections filed by respondent number 1, clause 8 of the bylaws at page 16, my lords, running page 16, numbered by them. At the bottom, Lord, your lordships will see clause 8, method of recruitment and minimum qualifications for appointment. Lords, A may not be relevant for today's case, Lords. If I may take your lordships to the next page, C, Lords. While making recruitments promotion to any post, the rules of reservations for persons belonging to scheduled caste or scheduled tribes and other backward class as made from time to time by the state government shall be followed. The next is relevant to us, Lords. Director cum dean, principal, medical superintendent, head of department, professors, associate professors, assistant professors, senior, junior, resident tutors shall be appointed as per the minimum qualification, experience prescribed in the CRL rules and NMC TEQ, minimum mandatory requirements. NMC TEQ were the regulations which I read out, which I not annexure in the writ petition notes. Those are the very regulations which provide for inter-se vertical seniority. Your lordship saw that yesterday at
Here the selection is for the post of dean.
dean and director. They have to follow what is under the requirement in the NMC notes. Now, what is prepared minute is being misled. It is not as per this notes.
C&R rules.
C&R rules is 5 senior most professors of the cadre notes. Cadre is a combined cadre which they have not prepared notes. What they have done is not from the date of appointment of that is not the requirement. It's inter-se vertical seniority where the entire length of service. These lordships we should keep in mind. These are appointments to the post of administrative post notes, not any teaching cadre, where the experience of the person over the years notes. Yes.
Now under the you are required to appoint in terms of the
TEQ regulations.
C&R rules
Please.
and whatever.
Yes.
And NMC TEQ.
Yeah.
Now you have prepared a provisional seniority list, isn't it?
Yes.
As on date. You prepare a final seniority list.
Yes.
Prepare a
Finals.
fin-
We have prepared a
Provisional seniority.
provisional seniority list against which the present writ petition is filed.
Correct. Now you prepare the final seniority list.
We will do it.
Prepare it. Keep it on hold. Keep the recruitment of director on hold. You prepare the final seniority list. Let them file their objection. You consider it. We'll also consider.
We've already filed the objections, Lords.
We will prepare it, my lord. As no, my lord, now your lordship may kindly consider this, my lord. There is a vacancy of the director and DG, my lord, for the last.
Ad hoc, you make an arrangement.
There's already an arrangement in place, my lords. There is already an arrangement in place.
My lord, that they are the, my lord, eligible for, my lord, selection to the post of director and dean. They can also apply.
That eligibility is still to be decided. Your seniority list, provisional seniority list,
My lord, see,
they are challenging it here.
it's not only my lord, consideration of seniority, it is my lord, other requirements also to be considered, my lord, under the bylaws. As yesterday, my lord, I read out, my lord, the bylaws.
You keep it on hold. We'll decide this matter. There's no point in permitting you to fill it up unless the seniority issue is also decided. If seniority is on what basis, date of appointment or whatever, as per the judgment of the coordinate bench, that will have to be followed. They are saying that is not followed. You have filed, a writ appeal has been filed, order is not stayed. Then where are we?
After the draft is prepared, my lord, they have filed objections. We will take a final decision on that draft of, my lord, seniority
You
list.
keep it on hold, you get the writ appeal decided, get this matter decided, and then you go ahead. Till then, you continue the officiating process. Nothing is settled now. With nothing settled, you can't go ahead with the filling up of the post of the dean. You continue, you make ad hoc arrangement on rotation. Let everybody get a chance and let the litigation be settled on its own. There's no shortcut to it.
Lords, it can all be solved within a matter of a month's time. They prepared a combined seniority list, my lords, which they have, for God knows why it's not being done, lords. My application for stay, my lords, and
They are
next
not
week,
allowing us to, my lord, to finalize the seniority list.
nobody is stopping.
Because one writ appeal is filed and another, my lord, is challenging the provisional seniority list.
What to do?
Oh.
All the
Your lordship
litigations
may
must be
kindly,
settled.
my lord, direct us to, my lord, finalize and proceed with the.
Correct, but then this matter has to be decided. How you are going to create the seniority list is a matter we have to decide. If you are going to take the stand, No, I'll give you one option. Suppose you say you are accepting the coordinate bench judgment as of now, and you'll prepare the seniority list, there ends the matter. They
Yes,
don't have
Lords.
any
Yes,
grievance.
Lords. In
Suppose
fact,
you were to say that,
Date of the order of appointment, my
the
lord.
coordinate bench order which you have challenged.
Yes, my lord, we will prepare, my lord,
Now, if you were to take a stand that in terms of the order of the coordinate bench, which is in writ appeal, which has not been stayed, you will take note of that and finalize the final seniority list. They have no grievance. If you take such stand in writing, I will observe that. And then finally, whatever happens would be subject to the outcome of the writ appeal. As of now, you prepare as per the coordinate bench order, there ends the matter.
yes.
yes, my lord.
Get instruction.
Your lordship pass it out, my order on Monday, my lord, I will.
Just get
Lords,
instruction.
Mondays, till such time it may be stayed, my lords. Because Monday is the last date, 4th. In fact, my lords,
Not filing application, there is no bar for them, my lord.
So
Why my,
you can't go ahead and.
they don't, my lord, even they have not applied. They can apply.
we don't know who has to
on
apply, my
Monday.
lords. All 400 have not applied.
Not be eligible to apply unless the issue of seniority is settled. The issue of seniority cannot be settled unless this court and the division bench decides. So until the division bench decides and this court decides, you can't fill up the post, that's all. We can't help it. It has the litigation takes its own course. Service matters are complicated, requires resolution after detailed hearing. So in the meanwhile, if you were to recruit, how you are going to fill up the post, how you are going to take seniority, that cannot be decided by you on the basis of provisional list, which is challenging.
My
We will,
application
my
for
lord, we will
stay is.
decide, my lord, the provision, the final seniority list, and thereafter we will proceed with the selection.
Yeah, so you defer it for the present. We'll hear the matter and we'll see. Or you get a order from the division bench. Suppose before the division bench, you move an application seeking for permission to go ahead in preparation of the seniority list, either in terms of the coordinate bench order, which you have challenged,
Yes.
or on the basis of contentions that you are advancing in the writ appeal. If the writ appeal, the court gives you permission to prepare seniority list, apart from the methodology of the coordinate bench, there ends the matter, then you can do it however you want.
Such an oral application was rejected yesterday, my lords.
You take, for clarity to be there, now you have challenged the judgment of the coordinate bench, isn't it? Now, if you have to prepare a seniority list, either it has to be in terms of the order of the coordinate bench or on the basis of your contentions that you have raised in the writ appeal, challenging the order.
They
of
have
the
not filed writ appeal. Yes.
challenging the order of the single judge. Somebody has challenged. Now, if you are sailing on the same boat as that other private person who has challenged the order of the coordinate bench, then you make an application because you are the person who's now going to select the dean, isn't it? For the purpose of selection of the dean, seniority is one of the issues. How that is to be prepared, that is a matter still not decided. So you file an application and obtain clarification before the division bench. If the single judge's order is stayed, there ends the matter. Then the seniority list can be prepared in a manner different from that of the coordinate bench.
That writ appeal, my lord, is posted for final hearing in the second week of next month, my lord. And they, my lord, in that writ appeal, my lord, they asked for an interim order of stay, wherein, my lord, yesterday I read out, my lord, that any action taken by the, my lord, the respondent is subject to result of the appeal.
So then the effect is that you will have to prepare seniority list by taking note of the order of the coordinate bench. If you were to take such stand, I'll record it and then you finalize the seniority. I'll have it. Now you
Yes,
take.
my lord, if the present, my lord, the provisional seniority list is prepared only as per the directions
No.
of the learned single judge.
Then that will decide. If it is not so, then we'll have to stay it. Now you point out.
Yes.
Again, you just point out. No?
Yes. Let's learn it single judge's order if I may take a operative portion.
Yes.
It's that will also annexure L of the main petition at page 141 minutes. The operative portion Lordships will find at 173 minutes.
Yeah, this writ petition was.
Of the writ petition, yes, ma'am. If I may read, Milords, operative portion. The writ petitions are allowed in part. It is hereby declared that the two impugn final combined seniority list dated so and so.
But why you have not challenged the new rules?
It's new bylaws, Milords. No, it's bylaws, Milords, because now I read out your Lordships. Bylaw 8, Milords, provides that they have to follow NMC regulations. Bylaw 12 is contrary to that. I'm supported by Honorable Supreme Court judgment which says that between bylaws and the statute, if bylaws has to yield to the main, and if the bylaw is contrary to the main act, it has to be ignored. May I not pass on that judgment? Milords?
Okay, let's go to the single judges.
Yes, single judge. 173 minutes. I was reading that portion. Clause 3 was the direction given. After setting aside two orders, the governing council of the first respondent medical college and research institute is hereby directed to consider the 5 senior-most professors in various specialties categories on the basis of merit list furnished by the KPSC to the government, and on the basis of which the appointment orders were issued to the petitioners in the respondent hearing. May I also seek your Lordship's permission to rely on two other regulations which the learned single judge court relied on at para 23, page 171 minutes.
So,
yes.
Consider 5 senior most.
Yes.
And
As
senior and take note of merit.
KPSC merit list.
Merit list of KPSC.
Yes. On the basis of which appointment orders were issued.
And okay, merit list of
basic KPSC merit list. But if I may, what also was relied on by learned single by the court earlier in laws was at para 23. Two other regulations.
Now this seniority list.
Yes.
Was directed to be redone.
Yes.
So what are the observations, how it must be done?
Yes, I will just point out that para 22 onwards. Rather, Milords, to get the gist of it, if I may repeat, Milords, para 21 onwards, from running page 168.
Now, yesterday's arguments I have forgotten. So
yes, I will. Milords, may I just for a minute take notes. Milords, now the Honorable Supreme Court, Milords, in Ramachandra Rao, I have produced that citation also. What the Honorable Apex Court says is not when it comes to administrative posts, it has to be for the entire length of service is the criteria, and it cannot be from a date of appointment of any professor and all, because sometimes junior gets opportunity earlier to become professors in some other department based on their specialities. That is what has happened here, Milords. Some of the juniors have overtaken us, though they were appointed much later, Milords. But therefore, Milords, Honorable the court, Milords, observe the para 21, page 168. If I may read that paragraph, notes, that gives the gist of it, why it was done. It was noticed by the Honorable Supreme Court in Dr. N. Ramachandra Rao that regard being had to the fact that in medical profession, there are several specialities and each subject have their own relative importance. It was noticed that there may be some subject or specialities which may be more important when compared to others. It was also noticed that promotional avenues would open up in each of the specialities, and for various reasons, it is found that in some specialities, the promotional avenue may not open up so easily as in the case of other specialities. Having noticed all these vagaries, the Honorable Supreme Court opined that the juniors who get accelerated promotion on account of fortuitous circumstances, depending upon their specialty and availability of vacancies, in such specialties should not be allowed to march over their seniority for appointment to administrative posts. Any advantage gained by juniors on such fortuitous circumstances should not impair the rights of their seniors for promotion to posts where specialty or teaching experience is not called for. The seniority determined in order of speciality should not therefore be the basis for promotion to administrative post. It was finally declared that any rule providing for contrary may be vulnerable to attack on the ground of arbitrariness. On the contrary, the decision cited by learned so and so governing on the rules of governing absorption. Next paragraph. 22. In the considered opinion of this court, the observations of the Honorable Supreme Court in N. Ramachandra Rao are aptly applicable to the facts and circumstances of the present case. We are dealing with an appointment to an administrative post in the present case. Therefore, having regard to the requirements contained in the cadre and recruitment of the Respondent Institute, for considering for the appointment of post of Dean and Director and other administrative posts, the requirement is that 5 senior-most professors should be taken into zone of consideration. The concept of preparing a combined seniority list for purpose is not provided for. In fact, even for the purpose of promotion, the court did not find any such requirement of preparation combined. Nevertheless, for our purpose, it is sufficient to notice that as per the requirement found in the C&R rules for appointment to administrative post, more particularly the Dean cum Director, 5 senior most professors in each category required to be considered. But these regulations also support this. The clarificatory note contained in Karnataka Medical Service Teaching and Technical Personnel in Medical and Dental Colleges Recruitment Amendment Rules 2001 makes it clear that notwithstanding anything contained in the Karnataka Civil Service Seniority Rules, inter-se seniority of professors shall be determined on the basis of total length of service put in the cadre of lecturer, assistant professor, and professor. This again is reflected in the teacher's eligibility qualification in Medical Institution Regulations 2022 of the National Medical Council in clause 3.10, which again provides that for the purpose of appointment to administrative post in government institutions, inter-se vertical seniority as on the date of entry into the institution government service is the requirement. On the plain reading as held by the Honorable Supreme Court in the case of N. Ramchandra Rao, it is clear that when the petitioners along with contesting respondents were appointed under an order dated 29/5/2000 and the petitioners were placed higher in the merit list when compared to the contesting respondents, and on account of some fortuitous circumstances, if the respondents gain accelerated promotion in their specialized field, the right of the petitioners for being appointed to an administrative post cannot be scuttled on the ground that the respondents were promoted as professors much before the petitioners. It is these circumstances that were aptly noticed by the Honorable Supreme Court, more particularly for the purpose of appointment to the administrative post. Now, if I may just read out those two regulations which are now referred, the NMC regulations, if annexure Q, page 180.
Now the provisional list that is prepared.
Yes, it is not prepared as per this. What they've taken is only date of appointment of service. I have, along with my application for stay, pointed out in a very brief thing, how such a big difference it makes in the manner it's published, in the manner it ought to be published. May kindly take my application for stay. I've prepared a comparative table, to demonstrate how the impugned order is illegal. Page 61, annexure Y, along with my application for stay. It's filed on 22nd. Page 61, annexure Y. The lordships get that. The first is the name, Lords.
Just 1 minute.
Yes.
So the single judge has said that the seniority list must be made across specialities, because in some of the specialities, some of them may have got accelerated promotion due to whatever reasons.
Yes.
So after preparing a
Combined
combined seniority list across specialties,
Yes.
Then you further process can go on.
Yes. Yes.
And
Now,
while
Lords, one
preparing
such.
while preparing a further combined seniority list, the entirety of the length of service
Yes,
needs to be
yes,
taken,
Yes.
and not merely seniority in that specialty.
Yes. Yes.
That's what.
Yes. Yes. That is what was. Now, annexure Y, page 61. I have given two comparative list notes. One in between is rank in impugned list, annexure M, which is challenged. And the one across is rank in the merit list, which was provided as annexure 2 in the thing. The lordships will see 1, 2, 3. One was in the additional list, much lower. Serial number, I'm now referring to the third column, rank in impugned list. It's 1, 2, 3. 2 and 3 were not even there in the list. And now in the impugned list, they have given the rank of number 2 and number 3. And lordships will see as and how we go down the table, 1, 2, 3, 4, 5, and the parallel ranking in the merit list is way beyond. And if you lordships were to see the petitioners on the next page, serial number 22 is the petitioner, Lords. In the impugned list, I'm at 22, whereas in the merit list, I'm on 18, Lords. In fact, here at serial number 3, doctor, I will not name the doctor, serial number 3. Lady doctor was absorbed, in the respondent by institution in 2008, and she's been ranked as number 3, She cannot be in the list at all, Now, come to the next annexure Z, page 63, This I've given, to show how I will be now eligible, I'm the only contestant, now. This is, names which appeared as per merit list, which annexure B provided, Your lordships will see the petitioner's name at the serial number 18 bottom, Now, if I may take, from 1 to 17, none of them as on today are eligible, I'm the only person now, eligible, because, I've given comments. I will not trouble the court with the comments, Some of them did not join, some of them joined Mysore Medical College.
Now this notification provided for recruitment, for the appointment of dean.
Yes.
Just take me to that.
Yes, notes. In the very same application, notes, Annexure V is at page 49 minutes. Application for stay.
This is a new notification.
Yes, this is the notification dated 1910 minutes.
Now,
They say,
just 1 minute.
yes,
Point number 2,
yes, no,
10 more senior professors.
yes.
So that you are saying cannot be decided on the basis of the provisional seniority.
Who are the 10 senior most? It has to be in the combined cardamom notes
So
there.
your contention is
Yes,
that this, if they go ahead with the seniority list prepared provisionally,
yes,
which according to you is contrary to single judge's order,
yes.
then you may be out of this.
I will, no, notes. I will not be there at all.
Point.
Yes,
So you are saying that this question of seniority list, unless that is settled,
it's echo.
unless that is settled, you for though this whole process with seniority will be faulty.
Yes, notes. Unless they prepare a combined seniority list as per NMC, let us now for a minute, notes, keep aside learned single judge's order because in challenge notes.
No, but it's not.
No, notes.
stayed.
I'm
It's
yes,
not stayed.
yes, note.
So till
Yes.
till it is not stayed,
Yes,
that will have to be followed.
Yes.
Rightly or
yes, that's what I'm saying. Apart from that, for a minute, if we were to keep that also aside, there are other regulations, NMC regulations, TEQ regulations, the rules minutes of a medical college, which everything is gone.
Yes, what do you say? So that's all. Now unless the seniority issue is thrashed out, who are the 10 more senior professors eligible? That is a matter to be still decided, because the provisional list of the 10 more seniority in which the petitioner does not find in the
Yes.
10 senior,
Yes.
you are not there.
Because in fact, the requirement is 5 senior most. Even in the learned single judge order says it's 5. The CARD and C and R rules say 5 senior most minutes. If I may point out.
No, correct.
Yes.
Now this says 10 senior.
Bylaw says 10. Whatever the 5 or 10 minutes. In the manner it has to be prepared.
Now, as per the.
Are you in the provisional list? Do you come within the 10?
No minutes. I don't.
So that is a matter to be decided.
Yes.
Finally.
Yes. Unless they prepare a combined seniority list minutes in the intergnum.
Unless the writ appeal is decided, you can't do anything technically. Let us. What is the stand you have taken the statement of objections?
Not filed, my lord.
No, they have filed.
Statement of the objections have been filed, my lord, because my lord, after filing the writ petition in 2024, new bylaws have come. New bylaw, my lord,
No,
says
but,
that.
No, correct, but with respect to appointment of dean, the second point is 10 senior most. Second point in the notification of the amended bylaw, which you have advertised in the notification, you have said 10 senior most.
Yes.
So that determination of 10 senior most cannot be done till this matter is decided. In the 10 senior
10,
most.
my lord, it is not that, my lord, 1 to 10, my lord, will be
That's a different
listed.
matter. No, that's a different matter. But if they don't have seniority, then on merit, even those bottom also will come.
No,
But
not that, my lord. There is a, my lord, requirement, my lord, qualification and their performance, my lord, publication, my lord, their thesis and
seniority cannot be ignored. It says
seniority, my lord.
That is still to be decided. That we have not decided. Until
Suppose, my lord, even if they are seniors, if they have not performed.
Correct, but who's senior? Who's senior? We don't know. The petitioner has filed the present.
Your lordship may, my lord, allow us to, my lord, to finalize the seniority list.
It has to be decided. Petitioner has called in question validity of the provisional seniority list of eligible professors for permanent appointment to the post of director, dean. Full stop. The counsel for the petitioner submits that the provisional seniority list that is prepared has been prepared contrary to the order of the coordinate bench.
141.
Page
141.
passed in the case of Deepak Shivanna versus Bangalore Medical College and Research Institute in WP 8306 of 2020 called 14144 of 2018, in which the present petitioner was a petitioner. Full stop. It is submitted that the seniority list prepared was set aside in the above mentioned writ petition. And the final combined seniority list dated 22/2/2018 and 28/8/2019 were set aside.
Yes.
Full stop. There was a direction by the governing council of the Bangalore Medical College and Research Institution to consider the five senior most professors in various specialities on the basis of merit list furnished by KPSC to the government, and on the basis of which appointment orders were issued to the petitioners and respondents. Full stop. Counsel for the petitioner draws attention to the observations made from para 21 onwards. Full stop. The observations made at para 21 onwards, and submits that the direction for redoing the seniority list, which would eventually have a consequence as regards appointment to administrative posts, is by taking note of the direction of the Apex Court in Dr. N. Ramachandra Rao's case. Citation?
It's produced notes at Annexure R 1993 SEC 590. Annexure R 203 is the citation.
Reported in 1993.
Yes.
1990.
Yes.
Volume 3.
Yes.
SEC 590.
Yes.
State of Andhra Pradesh versus Dr. N. Ramachandra Rao and others. Full stop. It is further submitted that the coordinate bench was clear in its reasoning that the seniority list ought to be prepared by taking note of combined seniority in the entire length of service, and cannot be merely on the basis of seniority in the specialty, as some of the employees would have obtained accelerated promotion due to various factors referred to as fortuitous circumstances. Accordingly, it is submitted that the present action of the respondent in seeking to fill up the post of dean by inviting applications by notification dated 19/10/2024, which takes within its fold the aspect of seniority at point number 2 in the criteria for appointment, cannot be permitted to be proceeded with unless the issue of seniority is decided. Full stop. Learned counsel appearing for the respondent institute submits that the order of the coordinate bench has been challenged by one of the other employees in writ appeal
439 of 22.
439 of
22.
2022. Full stop. It is an admitted fact that the order of the coordinate bench referred to above has not been stayed till date in the proceedings pending before the division bench. Full stop. Learned counsel for the respondent Sri Mali Patil would however submit that what requires to be noted is that new bylaws have been framed, copy of which is produced along with the statement of
R2.
copy of which is filed along with the statement of objections, at annexure R3.
Yes.
And in terms of the said bylaw, the selection of a dean is provided for at bylaw number
12.
12. Page 21. Bylaw number 12. And in terms of the said criteria at point number 12 of the bylaw, seniority alone may not be a tilting factor, as other criteria are also prescribed, including eligibility criteria mentioned in the C&R rules of the institute.
Including publication and additional.
It is further submitted that in terms of the amended bylaw at clause 12, merit is also to be taken note of, which includes publication of original research articles, additional other factors such as additional experience as professors, holding of patents if any, administrative experience, etc. And accordingly, it is submitted that the issue of seniority by itself may not be the sole factor involved in the selection of the dean. And if that were to be so, the notification inviting for filling up of the post of the dean may be permitted to be proceeded with, while needless to state that the division bench order would govern the final decision regarding the seniority list. Next, heard both sides. It must be noticed that the seniority list, provisional seniority list is in challenge in the present proceedings. It is the submission of learned counsel for the petitioner that the provisional seniority list has been prepared contrary to the order of the division bench, contrary to the order of the coordinate bench passed in WP 8306 of 2020. A perusal of the order in WP 8306 of 2020 refers back to the order of the apex court in Ramchandra Rao's case, and as pointed out by counsel for the petitioner, the mandate in Ramchandra Rao's case is that seniority list must be prepared by taking note of the entirety of length of service and not mere seniority in the specialty. This order of the coordinate bench admittedly has not been stayed in the writ appeal proceedings. And in fact, the division bench has clarified that this court is to take a final call insofar as the contentions are concerned, as reflected in the order of the division bench dated 5/7/2022. It would be of relevance to notice the observations made by the learned single judge, which has a bearing on the manner of making the seniority list at para 21 to 24, which reads as follows. Next, order of the division bench dated 5/7/2022 reads as follows. Next, though it is the contention of counsel for the respondent that the methodology of selection is as per the new bylaws. However, it must be noticed that a perusal of the advertisement notification produced along with IA for stay
49 minutes. 49.
would indicate that at point number 2, that the 10 senior most professors shall be shortlisted from the same institute under the head criteria for appointment. The point number 2 in the criteria for appointment, page 49. Point number 2 reads as follows. If that were to be so, the seniority of the professors would be a vital factor to be taken note of to determine eligibility. In terms of the C&R rules, page
It's page 129, annexure H,
29.
120, along with the main petition. So we'll find it page 131, subsequent income director, 131. Second clause on the extreme right.
the selection prescribed under the C&R rules is seniority cum merit. Full stop. Needless to state, any bylaw framed by the respondent cannot be contrary to the C&R rules. The question of seniority cum merit is a matter still to be decided. The provisional list takes away the right of the petitioner even to apply, as the petitioner is not within the 10 senior most professors. As to whether the provisional seniority list prepared, which has been challenged in the present proceedings, is to be upheld or not is a matter still to be decided. If that were to be so, the question of proceeding with the notification to fill up the post of dean cum director as per annexure
V, page 49.
V would not arise. Accordingly, the process pursuant to annexure, accordingly, the process contemplated at annexure V is to await the outcome of the present proceeding. There would be, accordingly, there would be a stay of annexure V and subsequent proceedings pursuant thereto. Till such time, this either the interim order is revised or the direction of the writ appeal in the division bench is made. The present in charge arrangement may continue while keeping it open for the respondents to make changes in such in charge arrangements on an ad hoc basis, on the basis of certain guidelines to be adopted by them.
May I make one submission? In view of honorable division bench finding that let learned single judge decide this, and not in view of the fact that there's no stay order in writ appeal, a liberty could be given to respondent one to prepare combined seniority list in terms of learned single judge order.
Let them take that stand. They want to
If that could be observed, my lords, it could just make matter easier and faster, my lord, for the entire institute.
Needless to state, it is open for the respondent, if they so desire and circumstances are so made out, to prepare seniority, taking note of the directions of the coordinate bench, for which the petitioner has no objection.
Yes, grateful.
Period for respondent number 3. Pray for 1 week time, but we will file our objection.
Lord, in this case, my lord, this has been going on for the past 2 months. My lord, the petitioner, my lord, in both these petitions, my lord, they are retired professors, my lord, from the, insofar as the first writ petition is concerned, my lord, he's a retired professor from Mysore, from Kuvempu University, my lord.
For my learned friend, my lord, previous on merits, my lord, I would like to bring your lordship notice. I have filed my detailed objections, my lord, on behalf of University of Mysore in first petition. That, my lord, under identical circumstances, my lord, the say of the state government also, my lord, is required because it's because of state government order, my lord, all these things happen. They have to make their submission whether what has to be done in this regard. My lord, in fact, this honorable court, my lord, on 24th May 2023, my objections may kindly be seen. In that, I have produced an order copy of the passed by this honorable court. Under identical circumstances, there is a direction issued to the state government, my lord, to take a stand and take a decision. Which, my lord, if they say what decision they have taken, my lord, based on that, my lord, this matter could be disposed of. Because your lordship may kindly turn to page 13 of my statement of objections. There, my lord, identical circumstances, my lord, because it is the state government, my lord, which has the government order which has caused all these anomalies, my lord.
Clause?
Lord,
Annexure R2.
my lord, maybe
R2,
some,
my lord, page
R2, my lord, filed by respondent number 4, my lord, University of Mysore.
My lord, some bare minimum facts may be, my lord, required to be stated before that, my lord.
Annexure R2, my lord, is the order. Page number 9.
Order of the coordinate bill.
Yes, my lord. That is in 7154 of 2021. Let me read, my lord, the para number 7, my lord, this relevant portion. In the light of the submissions made by the learned counsel appearing for the parties, the result of the writ petition indicate that the respondent number 3, Mysore University, has addressed a letter to dated so-and-so to the respondent number 1 to take a decision in the matter. In that view of the matter, I am of the view that a matter is pending consideration before the respondent number 1, my lord, which is state government. Respondent number 2 is directed to consider the letter dated so-and-so. Insofar as the remaining reliefs are concerned, as the respondent number 2 itself has already rejected.
3 months, just one.
Yes,
3
my
months time is given.
ಹೌದು ಅದೇನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು we are not aware, my lord,
Lord,
what
this has
government
nothing
has
to do
taken.
with, Lord, as far as this order is concerned. Lord, this has nothing to do with the controversy involved in this, in the instant writ petition. Lord, here the government has already taken a decision and has directed the Mysore University, my lord, to take action as per law. That order I have produced, please have a look at Annexure M, page 55. My lord, here what happens is that, my lord, the petitioner, my lord, he had rendered 19 years of service in Mysore University. Then, my lord, he tendered technical resignation under Rule 252B of KCSR for being directly appointed as a reader in Kuvempu University. Now, my lord, since it was, there was no cessation of employment and, my lord, it was by virtue of the technical resignation, my past service rendered in the Mysore University, my lord, has to be reckoned for all practical purposes, including pension and terminal benefits.
So the rule itself.
Yes, my lord, because it is only a technical resignation. Now, my lord, I have been making representations to the university, to that is not to the Mysore University, to forward whatever accrued benefits towards EL encashment, pension and gratuity to be transferred to Kuvempu University. Now, my lord, the government has passed an order. Please have a look at Annexure M, page 55. There is already a direction. My lord, this is dated 18/9/2021. I'll just read from para 2. ಡಾಕ್ಟರ್ ಜೆ ಸಣ್ಣಪ್ಪ ಪ್ರಾಧ್ಯಾಪಕರು ಭೌತಶಾಸ್ತ್ರ ವಿಭಾಗ ಕುವೆಂಪು ವಿಶ್ವವಿದ್ಯಾನಿಲಯ ಶಿವಮೊಗ್ಗ ಇವರು ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾನಿಲಯದ ಘಟಕ ಕಾಲೇಜಾದ ಯುವರಾಜ ಕಾಲೇಜಿನಲ್ಲಿ ಭೌತಶಾಸ್ತ್ರ ವಿಭಾಗದಲ್ಲಿ ಉಪನ್ಯಾಸಕರಾಗಿ ದಿನಾಂಕ 10/9/92ರಿಂದ 3/11/2010 ಸೇವೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾನಿಲಯದಲ್ಲಿ ಸೇವೆಯಲ್ಲಿರುವಾಗಲೇ ಸ್ವಹಿತಾಸಕ್ತಿಯಿಂದ ಕುವೆಂಪು ವಿಶ್ವವಿದ್ಯಾನಿಲಯದಲ್ಲಿ ಯುಕ್ತ ವಿಧಾನದ ನೇಮಕಗೊಂಡು ದಿನಾಂಕ 31/5/21 ಸೇವೆಯಿಂದ ವಯೋನಿವೃತ್ತಿ ಹೊಂದಿರುತ್ತಾರೆಂದು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತೀರಿ. ಆದುದರಿಂದ ಡಾಕ್ಟರ್ ಜೆ ಸಣ್ಣಪ್ಪ ಪ್ರಾಧ್ಯಾಪಕರು ಭೌತಶಾಸ್ತ್ರ ವಿಭಾಗ ಕುವೆಂಪು ವಿಶ್ವವಿದ್ಯಾನಿಲಯ ಶಿವಮೊಗ್ಗ ಇವರಿಗೆ ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾನಿಲಯದಲ್ಲಿನ ಸೇವಾವಧಿಯ ಪಿಂಚಣಿ ಹಾಗೂ ಇತರೆ ಸೌಲಭ್ಯಗಳನ್ನು ನಿಯಮಾನುಸಾರ ಬಿಡುಗಡೆಗೊಳಿಸಿ ಈ ಬಗ್ಗೆ ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಲು ನಿರ್ದೇಶಿತನಾಗಿದ್ದೇನೆ. My lord, pursuant to this direction.
No, you were earlier working in?
My lord, initially I was working in Mysore University. I have rendered service of about 19 years, my lord, in Mysore University. Then, my lord, in the year 2010, pursuant to a direct recruitment notification issued by the Kuvempu University, my lord, I applied for and I was appointed as a reader in Kuvempu University.
After getting permission?
After getting due permission and, my lord, after rendering technical resignation.
No, the direction of the government is to release the benefits insofar as service rendered
in Mysore University.
In Mysore University.
Yes, my lord, because this is addressed to Kulasachivaru, Mysuru Vishwavidyalaya, Manasa Gangotri, Mysuru. And pursuant to this direction, my lord, university has also passed an order. Please have a look at page 56, Annexure N. My lord, this is dated 30th of October 2021. ಮಾನ್ಯ ಕುಲಪತಿಗಳ ಅನುಮೋದನೆ ಮೇರೆಗೆ ಹಾಗೂ ವಿಶ್ವವಿದ್ಯಾನಿಲಯದ ಸಿಂಡಿಕೇಟ್ ಸಭೆಯ ನಿರ್ಣಯವನ್ನು ಕಾಯ್ದಿರಿಸಿ ಉಲ್ಲೇಖ ಪತ್ರ 3ರ ಸರ್ಕಾರದ ನಿರ್ದೇಶನಾನುಸಾರ ಡಾಕ್ಟರ್ ಜೆ ಸಣ್ಣಪ್ಪ ನಿವೃತ್ತ ಪ್ರಾಧ್ಯಾಪಕರು ಭೌತಶಾಸ್ತ್ರ ವಿಭಾಗ ಕುವೆಂಪು ವಿಶ್ವವಿದ್ಯಾನಿಲಯ ಇವರು 10/9/92ರಿಂದ 3/11/2010 ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾನಿಲಯದ ಯುವರಾಜ ಕಾಲೇಜಿನಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಸೇವಾವಧಿಯ ಪಿಂಚಣಿ ಹಾಗೂ ಇತರೆ ಸೌಲಭ್ಯಗಳನ್ನು ನಿಯಮಾನುಸಾರ ಬಿಡುಗಡೆಗೊಳಿಸಲು ಆಡಳಿತಾತ್ಮಕ ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿದೆ.
So administrative sanction was also accorded by the university. Then, my lord, this amount was also released. Please have a look at page 59, annexure Q. My lord, this is addressed by the principal to the finance officer of the university.
No, if for a moment,
Yes, my lord.
if you are eligible for whatever benefits for your service under the Mysore University.
Please.
Is for the time being.
Yes, my lord.
The time being settled.
Yes, my lord.
While whether the subsequent tagging and refixing of pension is a matter subject to final orders.
Please, my lord.
That would suffice for the time being.
My lord, for the, at least, my lord, there is nothing to fall back upon as far as I am concerned in both these writ petitions.
So who appears for Mysore University? So what we are saying, we'll decide the matter. Finally, whether the period for the purpose of pension from the Mysore must be tagged along with the subsequent service that he has done, which would have an influence on the final pension to be done. Now, as on date, insofar as what service he has already rendered, let that be settled. This matter will hear.
No, my lord, the government order, my lord, in 2006, there is a government order, says, my lord, those, my lord, those the employees, my lord, who have been newly appointed in the state government, they are not entitled for the old pension scheme. New pension scheme, what is applicable. So
Newly appointed.
Newly appointed.
How is
No, newly appointed for a direct, as a direct recruitment for a cadre, my lord, because they have to resign here. See, they were in the previous cadre.
What is the effect then? What is 252? Nothing.
My lords.
My lord, in fact,
52,
yes.
doesn't it not specifically say with respect to pension that service is to be counted? How you can ignore that?
No, my lord, my submission is, your lordship, kindly, state government itself, my lord, has clarified this about this. Your lordship,
Correct. So
kindly.
that will decide. What I'm saying for the time being, now insofar as service rendered in Mysore, irrespective, now let's assume that there's no tagging, and he had retired in Mysore. At
Retired
least-
Allah, he has resigned.
Huh?
He has resigned and he has taken up another job as a professor and he has gone to Coimbatore University. It's like that.
But with
It
your
is not that he would continue here after superannuation. I mean, he has not resigned after.
What is your stand, madam? What is it?
My lords, I'll have to take my stand. Your lordships may see annexure R, my lords, at page 60.
What is challenge is the government order.
Yes, my lords. There we state the following. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ KSSR ನಿಯಮ 235A ಪ್ರಕಾರ ಹೊಸ ನೇಮಕಾತಿಯು ಸಾರ್ವಜನಿಕ ಮತ್ತು ಆಡಳಿತಾತ್ಮಕ ಹಿತಾಸಕ್ತಿಗೆ ಅನುಗುಣವಾಗಿ ಪರಿಶೀಲಿಸಬಹುದಾದ ಸಂದರ್ಭಗಳಲ್ಲಿ ಮಾತ್ರ ಪ್ರೋರೇಟ ಪಿಂಚಣಿ ಪ್ರಯೋಜನ Now here, my lords, the petitioner has voluntarily resigned and moved to Coimbatore University, my lords. Now, in this situation, whether it can be carried forward is a stand we'll have to take in writing. My instructions would be that only when it is in the interest of public, when such a transfer has happened, then pro rata pension will be considered.
What happens to rule 252?
My lords, I'll have to say.
Give a rule for it. You can't take any action contrary to the rule. If a service has to be included, counted for pension, so be it. Then he'll be treated as in continuation in public service in terms of the rule, and the entirety of pension will have to be settled. Let them take a call, but I'm saying the 252
B, my lord, subclause B.
250.
252, subrule small b.
Yes. So what happens to this? Now, in case of pension, earlier,
Yes,
earlier,
ma'am.
before all this new pension thing came,
Please.
they would take note of both service.
Yes, my lord.
That's the procedure.
Yes, the
practice.
procedure, yes, my lord, because the pro rata, whatever accrues, my lord, before the previous, by the previous employer, lord, that has to be transferred to the new employer. Lord, it cannot be treated as a fresh recruitment post 1/4/2006.
So you're saying 250B, 252B will have I mean, they cannot take any action to determine your pension without taking note of continuity in service under 252.
Exactly.
That's your
Exactly. Yes. Now, on the last occasion, Lord, I had also placed on record one order passed by a coordinate bench of this Honorable court. Lord, that is in WP number 10327 of 2021. 10327 of 2021, my lord. It is in your lordship's file, my lord. On the last occasion I had.
Yes.
My lord, this is in relation to University of Agricultural Sciences, Raichur. Lord, paragraph 9 at page 7. Lord, identical claim was rejected by the employer on the ground that, my lord, the subsequent appointment should be treated as a new appointment. Paragraph 9. Respondent number 2, vide impugned endorsement dated 4/7/2018 has rejected petitioner's claim and petitioner's request to remit the pensionary benefits either to him or to respondent number 3, University of Agricultural Sciences, on the ground that his appointment is bound by new pension scheme introduced by Government of Karnataka on 31/3/2006. Petitioner was appointed as a seed certification inspector on 4/7/86 and worked in the said agency till 2/8/2000. Petitioner applied for the post of Associate Professor, University of Agricultural Sciences in the Department of Seed Science and Technology at Raichur. The application was admittedly routed out through the Karnataka Seed Certificate Agency. Therefore, service rendered by the petitioner in the agency from 4/7/86 to 2/8/2000 as seed certification inspector.
Now there, they have certain statutes.
Yes, my lord.
Yes, ma'am. Their statutes are
here-
different.
My lord, here what happened is that, my lord, they have, it appears, my lord, Mysore University has amended the statute and placed it before the government for its approval way back in the year 2014. Even after, my lord, nearly 7 years, that proposed amendment, my lord, is still with the government. Government is not
considered, my lord.
recording approval.
Correct. Now, this Karnataka Civil Service Rules is adopted.
It is adopted.
Wherever, my lord, our statute is not there, my lord, we will
Silent.
go back to the case.
So insofar as 252, in your statutes, 2B, 252B.
Yes.
Your statute, does it have any provision?
Lord, we have our own statutes, my lord. The copy I have produced along with the memo, my lord, on the last time.
So insofar as this continuity in service.
Yes.
Without reference to this, is there any reference to how pension is to be done if under 252B? Under the statute? Statute, is there any provision?
My lord, there is no provision under the
No provision, my
KCS.
lord, in
But, my
our-
lord, the fact remains that about 4 similarly situated professors, my lord, who were transferred to from Mysore University to other universities, my lord, they have been considered. Their cases have been considered. I have produced a series of documents to establish that fact in my writ petition. My lord, please have a look at Annexure T series.
So what is your stand then, man?
My lord, they have to make a stand.
What is your stand?
Stand in writing, my lord.
Take it, I'll fix a date.
Yes.
Now you can't not pay pension to a person. Now if you say that you can't even pay for the Mysore one, then where is he? How can he survive? So you have to take, I'll fix a date.
Yes, my lord, now that our difficulty is that, my lord, we have, in the first writ petition, he had retired in the year 2021. My lord, for the past 3 years, my lord, he has nothing, my lord, even for survival. As far as the second petitioner is concerned, my lord, he has retired in the month of May 2024. So, my lord, therefore, my lord, at least as an interim measure,
No.
let there be a direction, my lord, to pay them
Will
some.
No, correct. Now it falls in a narrow compass.
Yes.
the Issue. We'll dispose it off.
Yes,
If they don't file, we'll proceed.
And it is unfortunate that for the past 1 year, government is, my lord, has not even.
Why you have not filed statement? Then? There is no 252(2)B for government advocates. Earlier government advocate has gone. Relist the matter on 1 week admin date code.
It's 2 weeks.
10 days date code. 14th. It's made clear that if the state do not take their stand in writing, the court would be constrained to pass appropriate orders.
My lord, state will have to file its objections in this matter. I seek time.
Then file it by the next day.
Yes.
Statement of objections to be filed by the state, by the next date. Relist the matter on 21st.
Mobilize, my lord.
For the petitioners, my lord. My lord, order of the Joint Director of Collegiate Education, my lord, deputing teaching faculty of private aided colleges, my lord, to some government colleges are called in question. My lord, the very same government order, my lord, in respect of some of the other faculty, my lord, is quashed by this honorable court.
Set aside.
Set aside. I have even furnished a copy to my learned friend also. But very same, 27/2/2014, my lord, or 2024.
Not be applicable entirely, my lords. The order says specific to the petitioners therein. Also, there is an observation that a notice ought to have been issued and information ought to have been sought from the university as to the number of students and the hours of imparting knowledge, my lords. Now, the university is required to furnish this information, and that information is furnished to us based on which we may have passed an order. I'll have to secure instructions on that, my lords.
Same, my lord. Same. Here also. It's a straight jacket, my lord, order, my lord, without
Data
issuing notice.
furnished by the university.
My lord, before the,
No, correct. What I'm saying is, no, we'll give a date. If they don't file, we'll proceed further.
yes,
Whatever stand they take in writing, let them take.
yes,
We'll examine it.
yes.
State to file their pleadings by the next date. Relist the matter on. Yes, we'll see on this,
The same status.
in the same stage.
Yes.
For the petitioner, Lord, the petitioner is the employee of Lord Fourth Respondent Institute, which is a grant-in-aid institute, Lord. I have made a request for Lord voluntary retirement. Lord, my representation is at Annexure F, page 31.
That decision must be taken by.
Lord, the decision is taken by the Lord third respondent, rejecting my request on the ground that Lord, the provisions of KCSR has no application. Lord, endorsement is at Annexure G, page 33.
So the answering respondent is R3.
Yes. Lord, the Lord, page 33 is the endorsement. The sole reason is that Lord KCSR has no application. Lord, which is communicated to me at page 34. Lord, may I request my lords to kindly come to my lord page 35 at Annexure J. Lord, this applies to This is my lord grant-in-aid code pertaining to my lord private industrial training institute in Karnataka, revised 2007. Lord, your lordship may kindly come to chapter 5, para 24, which says that my lord, I am governed under my lord KCSR.
Governed.
Yes. Lord, para 24.
Page
45. General conditions of service. 24. General conditions of service applicable to government employees according to the provisions of KCSR as amended from time to time are applicable to the aided employees of service, ITIs including pension under triple benefit scheme as in vogue in the grant-in-aid education department and others. But if KCSR applies, Lord, Rule 285 provides for voluntary retirement. Lord, I have claimed, I have made request for my lord
285.
of the KCSR.
No. Subclause?
2, my lord. If I have completed 15 years of service, then I am entitled for to make an application for voluntary
So
retirement.
now the only ground is it's not applicable.
It is not.
That's all.
That's all. That is the only. They rely upon 1997 code that is revised in the year 2007 is my case.
This grant in aid code. Grant in aid.
Yes. Lord, page 33, they refer grant in aid code of 1997. My lords will find the last paragraph. ಮುಂದುವರಿದು 1997
There was, why was it not under that? What was the position?
it was not there. Not the code which I have showed is page 35, 2007.
What is the stand taken in the
My lords,
statement
we
of
filed.
objection?
Statement is not filed, my lord.
Objection.
They filed.
Yes. Our stand is that the grant in aid code is not revised, my lords. What is subsisting is the 1997.
Have a
grant in
look
aid
at it.
code.
We'll have it on Monday.
Madam, we'll serve them a copy.
Satish, you have a look at it. We'll have it on Monday. You're saying it is not revised.
Yes, my lords. Our stand
Then
is
he has produced it.
allegedly a draft, my lords, will make us.
Huh?
We say it's a draft, it's not, my instructions are that it's not revised.
Okay, just check.
We-
Please.
They're still relying on the
97.
97.
And 2007, if it is still draft after 17 years,
Not published in the Gazette,
No, my lords.
according to you. Anyhow, you find out. When do you want to?
but it was on 21st, my lord, my lords had heard and
No, now for you to check, whether that is the
Sixth.
final one or not, when do you want it?
6th.
6th. Release in same stage on 6th. Satish's clients will know more than the government. Yes,
Petitioner number 2. Kindly place short accommodation. It's
request.
This one.
What is the matter?
any date after 10th, my lords.
Problem.
47.
For the respondent, take up on 21st, my lords. Wrong.
Relist on.
Much of it.
48.
For petitioner,
Appear for the respondents.
here the petitioner is challenging the impugned punishment order produced at annexure A, your lordships. He has been penalized with compulsory retirement from the service. The allegations in the departmental inquiry is that the petitioner,
You complete at least preliminary instruction.
Yes, I required some time.
one submission, my lord, here. The impugned order is not passed by the competent authority. Board ought to have decided it, and the MD is the competent authority to pass the impugned order, whereas here in the present case, the director HRD has passed the impugned order.
Now under which regulation MD?
Yes, your lordships. Kindly page number 18,
Page?
18, 18 of the petition. Annexure A, this is the impugned order. Para 4 may be seen, your lordships. ACB ವತಿಯಿಂದ, this is a trap case, your lordships. Trap case. ACB ವತಿಯಿಂದ ಸ್ವೀಕೃತವಾದ ಲಂಚದ ಆರೋಪ ಪ್ರಕರಣಗಳ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಿಗಮ ವತಿಯಿಂದಲೇ ಇಲಾಖಾ ವಿಚಾರಣೆ ನಡೆಸಲು ತಿಳಿಸಿದ್ದರಿಂದ ವಿಷಯವನ್ನು ದಿನಾಂಕ 9/9/2020 ನಡೆದ ನಿಗಮ 121ನೇ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಲಾಗಿರುತ್ತದೆ. ನಿಗಮದ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಕೈಗೊಳ್ಳಲಾದ ನಿರ್ಣಯದನ್ವಯ ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ಮಂಡಳಿ ನೌಕರರ ಶೀನಿ ಮತ್ತು ನಿಬಂಧನೆ 14A ಗೆ ನಿಗಮದ ದಿನಾಂಕ 4/11/2020 ಆದೇಶದಲ್ಲಿ ತಂದ ತಿದ್ದುಪಡಿ ಅನ್ವಯ ಎಸಿಬಿ ಲಂಚಾರೋಪ ಪ್ರಕರಣದಲ್ಲಿ ನಿಗಮದ ಅಧಿಕಾರಿ ನೌಕರ ವಿರುದ್ಧ ನಿಗಮ ವತಿಯಿಂದಲೇ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಲು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. So for this a notification order has been passed at annexure M, your lordships. That is at page number 86. Based on these rules, this rule only, punishment order has been passed. Illi, as amended, ಕೆಳಗಡೆ on receipt of the records under regulation 14A 1D, the managing director KPTCL shall take action in accordance with the provisions of sub-regulation 21 and sub-regulation 23 of the regulation 11 and regulation 11A. And in all such cases, the managing director KPTCL shall be competent to impose any of the penalty specified in regulation 9.
Regulation 9, compulsory retirement includes.
Punishments,
Just
measure
show-
punishments.
Just show regulation 9.
Regulation 9, I'm not having, your lordship.
So compulsory retirement comes in the regulation.
Yeah,
9.
yes, your lordships. As good as rule, it is a replica of rule 9 of KCSR. So it is a measure punishment which has to be given by the MD. Again, it is, there should be a subcommittee. And that subcommittee shall consist of chairman, that is additional chief secretary to government, managing director KPTCL, director administration and HR.
This procedure according to you is not followed.
No, your lordship. In impugned order also, on page 21, impugned order only.
Let us see, let us see.
No, your lordship, again, tomorrow they will, I have prayed for interim stay of the
My lord, it may be
proceedings.
taken up next week, my lord. I have
Allah.
been instructed to appear, but I have not got the copies.
Copy
And
we
the
have served.
petitioner.
Copy we
Allah,
have served, your
Correct,
lordship.
correct.
Copy served.
One copy agide, but I have not received the copy. That is what I have been submitting.
KPTCL,
And
MD,
my lord.
the same
petitioner
authority.
Has not collected the compulsory retirement order also, my lord. He has not collected at all. And before even collecting the order, they have approached this honorable court. Whatever is the submission, I will make it.
Yes,
next
if,
week.
Just one.
yes,
No, you don't give effect to the order till the next date.
yes.
Next date will decide.
My lord, order is already passed. He has not taken it, my lord.
Correct.
He has
He
not
said-
collected.
He's saying the managing director
Yes,
doesn't have the
yes.
power to pass. He's saying in terms of your
Monday only it may be taken up. Next working day,
Regulation.
my lord. Whatever is my submission, I will put forth. Tomorrow, from tomorrow holidays only, my lord. Next working day,
we'll have it on Monday.
Monday we.
Tuesday. Till then the order may.
No, my lord.
Maybe.
And I have no
Otherwise,
instructions at all, my lord. Monday. ne
Again,
happen, sir.
my petition will be infructuous if the order is passed.
It's already passed, my lord.
Order is executed. Your
But
lord.
we have not filed KBS.
My lord,
No, they have not filed.
petitioner is purposely avoiding collecting the order, my lord. Order is already passed.
Correct.
That is my right.
No, just one.
That is my right.
No,
I have to
that's-
safeguard myself.
No, they're saying that the managing director has to pass an order in terms. Here, the order is not passed by the managing director, only on that point. I'll pass over, you get instruction,
It may be taken up on Monday, my lord. That's all.
but then don't relieve.
Yes.
At 2:30, my lord, whatever it is, I will.
So what he's saying,
Yes, I heard.
you heard the
Yes,
submission.
my lord, I heard.
You were there.
Competent authority has not passed the order.
He's saying under the rule, the authority to impose penalty of compulsory retirement is the managing director. In terms of,
Rule
Regulation 9.
14A of KB conduct and appeal rules.
that you show it.
Yes, I'll show it.
So he's saying that now the order is passed by
Director HRD, your lordships,
Director HRD.
without placing the matter before the MD or the board,
At annexure
independent,
M,
on his independent capacity.
annexure M,
M.
there is a procedure under regulation 14 capital A 1E, which says the managing director can impose a
I'll impose.
penalty under regulation 9 as
Yes.
content. And they say compulsory retirement falls within that 9. And if there's any divergence between the recommendation of the Upalokayukta, they will have to create a subcommittee.
And here, Upalok, at that time, your lordships, Lokayukta was, police station was abolished. And the investigation was done by ACB trap case. For that matter, the matter was inquired by the board itself.
In your preliminary submission, you see,
Yes, my
then
lord.
we'll see. if
Yes,
it's
yes, much obliged.
possible.
Applies.
That, yeah.
Let's see, here.
14. 15. 22.
Lord, this matter, my lord will recollect, was heard at length. Only few points that I had to make. Clarification is 22. Lord, the first one is cadre and recruitment rules do not provide for the qualifications said to have been got by the petitioner. Then a notification was issued pursuant to that. That notification was not questioned.
Just 1 minute, just.
You responded.
We'll do one thing. I'll take it up post lunch after the CMP matters.
Can I make a short request? No?
For R2, my lord. Short accommodation.
In the meanwhile, my lord, morning your lordship has directed them to place the government order. I am insisting on the government orders.
They produced it and
They are not yet produced.
you give a copy of that government order. Let us see what it's.
Yeah,
Yeah.
government.
Huh?
Which government order? is that?
Because there is a reference of a government order in the notification,
Yes.
whereby this diploma in painting is also been declared a equivalence. So
Relist the matter on
Fifth,
To 7th, my lord.
sixth model. Yeah.
12th.
Eighth ಆಗ್ಬೋದು. Can I request for eighth? Eighth ಆಗ್ಬೋದು. Whole of that week, please.
Friday is afternoon we'll have a division bench and morning we have some election matters. So it won't reach on Friday. We'll have it on 12th, let us see. 12th.
in the meanwhile, let them furnish that government order.
Relist on 12th.
Orders in the
Order of entrustment has been done.
Similar matter, my
On the
lord. has
jurisdiction,
stayed
my
at-
Where is the order?
Your lordship's order, my lords, at annexure Q, page number 121. And there are 5 interim orders, my lords, I have annexed pursuant to the division bench order.
After hearing Mr. Arbati, my lord, your lordship has passed this order.
Identical order.
Identical, my lords. On the question of jurisdiction, entrustment has to be by the BBMP commissioner, but here it is by the Urban Development Department.
Learned counsel for the petitioner submits that the entrustment in the present case by the
Urban Development Department Under Secretary, my lords.
Urban Development Department is impermissible
Please.
and not to have been passed by
The Commissioner BBMP.
the Commissioner BBMP. He submitted that in an identical factual matrix where similar legal question has arisen in WP 10801 of 2022. Court has passed an interim order and on parity, same interim order may be passed in the present matter also. The interim order passed in WP 10801 of 22 reads as follows. In light of the same, there would be stay of
Please,
Order of entrustment
please.
at annexure
Annexure N, my lords, N. N, N, my lords.
N. Annexure N. Division bench, no, nothing has happened.
My lords, I've also, my lords, I've also sought,
He won't mention.
my lords, I've also sought for consideration of his case for promotion. That has already also been granted in the, at annexure Q, my lords, in the lordship's interim order.
In light of the interim order passed, case of the petitioner for promotion without reference to the impugned order which has been stayed is to be considered.
Much,
First respondent has to consider.
please.
First respondent.
By the first respondent. 230, mentioning at 230. Mentioning at 230.
Yes.
For the petitioner, my lords, Annexure B is the agreement, my lords, which is digitally signed by the party. The office has raised the objection to produce the original. Annexure B at page number 21, my lords. It was executed during
In light
the,
of the explanation, office objection at serial number 2 is kept in abeyance. That's the only office objection.
please, my lords, remaining we have
So,
complied.
yes, agreement,
My lords,
clause,
my lords,
which clause?
my lords, at page number 44, my lords,
Huh.
article 27, my lords. My lords may kindly see, 27 clause, subclause 2 is the arbitration clause, my lords, and arbitration venue is at Bangalore. At page number 44, my lords.
No, but now this is by the Institute of Chartered Accountants.
My lords, clause 2, my lords. Clause 1, my lords, if at all any dispute with regard to accounting, my lords, clause 1 will apply. In other cases, my lords, if any controversy or dispute should arise between the parties in the performance, interpretation, implementation,
Now
or
you have
application of
issued
this
notice.
agreement. I am invoking clause 2, my lords.
Issued notice,
Please, my lords, I have issued notice.
page,
My lords, page number 57, my lords.
reply, or it served.
My lords, it is served, my lords, page number 64. In fact, my lords, they have issued a preemptive notice, my lords, we have replied. Then, my lords, we have sent it through email also.
Issue notice.
Please, grateful.
Serial number 2, my lords.
Yes,
My lords, I am for the petitioners. My lords, these are all the cases against the smart owner, which my lords would recover. Even day before yesterday, there were 7 matters.
yes.
My lords, this is invoking master service agreement, which we have filed this petition for arbitration. My lords, there are 2 office objections. One is regarding production of original document and how respondent 2 to 5 are made as a party. My lords, may please come to Annexure B MSA, my lords. My lords, this is a docu-signed document, my lords, computerized document.
Like
Page 16, Annexure B, my
yes,
lords.
yes. Office objection relates to production of original agreement. In light of the response of the council for the petitioner that the documents are
It is a docu-signed document, computerized.
computerized or digital documents.
Digital document. ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದೆ ಸ್ವಾಮಿ, docu-signed by ಅಂತ ಇದೆ with that ಇದು.
Digital documents. Accordingly, the office objection regarding non-production of original does not arise.
Please.
Then the other office objection relates to why
ಇದು making parties 2 to 5 as party.
why respond in all matters same, isn't it?
In all serial number 2 to 7, it is the same, my lords.
Why responding number 2 to 5 are made as parties in light of the submission made the by the council for the petitioner, said office objection is kept in abeyance.
Please.
Now same notice must be issued.
Please.
You have
Please.
served the notice.
Yes, my lords. In fact, the copies, my lords, may please turn to page number 28, my lords. Annexure E is all the postal receipts.
Issue notice.
Please, my lords.
On my,
2 to 7 is the same this thing,
yes,
my
yes,
lords.
yes.
And even serial number, my lords, 47 and 48 also same, smart owner only, my lords, for admission only. In fact, there is no office objection in that.
47 and 40.
47 and 48.
47 issue notice.
That is, one is C.R. Krishnamurthy and one more is Rajkumar Shivraj.
45. 45 issue notice.
I'm so sorry, 45.
ಆಮೇಲೆ
My lords, not 45, my lords. It is, one second, right away. I'll keep. Yes, my lords, I'm so sorry. It is serial number 45 and 47. I'm so sorry, I got confused. It is serial number 45 and 47.
45 and 47 issue notice.
Please, my lords. Grateful. Date, my lords?
Same dates.
Yavat that's what date.
Released on 21st.
Grateful, my lords. Deeply obliged.
My lord, I appeal for the petitioner, my lord.
Yes.
This is pertaining to the joint development agreement entered into between the petitioners and the respondent 1 to 4. The office objection is respondents 5 to 7 are the daughters of first respondent. They have filed a suit for partition and they got the right. Therefore, they have been made as a party. And respondents 8 to 10 are the subsequent the development agreement holders during the pendency of my agreement, my lord.
Office objection at seal number 2 is kept in abeyance for the present. Now the agreement clause.
Agreement class, my lord, page 21.
Clause number.
There is no class, my lord. It is a governing law and arbitration. Page 21, my lord. The agreement, according to the agreement, my lord, it comes to terms and conditions, class 5. And but the relevant para regarding arbitration is page 21.
You have issued notice.
I have issued notice at page 102, my lord.
Has it been served?
It has been served and they have replied also, my lord, on 6/8. Annexure J I have produced.
Issue notice.
And date may be fixed, my lord, at least.
21st.
Please, my lord.
Serial number 9.
Weeks time granted for necessary compliance.
10.
Same.
11.
Same.
13. 14.
CMP for appointment of arbitrator. I'll undertake to comply the office objection, my lords. Meanwhile, notice may be issued, please. The office objection is with respect to the agreement, please, my lords. And also that executant name must be mentioned in the wakalat. There are a couple of office objections,
You take up 13.
13 and 15, please, my lords.
So what is the office objection?
Executant name to be mentioned in the wakalat and also for the original of the agreement.
The answer is office objection. Yesterday. Now you have to comply. There are 7 office objections.
Well, let's undertake to comply in a
No,
week's
no.
time.
You have to comply. Compliance of office objection by next week. Relist the matter on.
14.
Waiting for petitioners on. Rest 2 weeks time, next week also.
2 weeks time for necessary compliance.
15. 15.
Weeks time for necessary compliance.
16.
Here for the, and this last one. I'm filing the memo. There are 2 things, clarifications that are sought. Being raised, my lord. This, the first one is that the provision of law is to be corrected. We filed it under section 11(4), since this involves appointment of 3 arbitrators, my lord, that 11(4) is the correct provision.
What are the office objections raised?
You know, the office objection at the first point is the provision of law to be mentioned correctly. We filed it under 11 subclause 4, my lord. That is the applicable provision whenever it is a question of 3 arbitrators to be appointed. And then, my lord, they have asked as to how the respondent numbers 3, 4, 6 to 10 and 13 are made parties.
No, just go one by one. Now the first office objection is
Provision of law, my lord.
yes. In light of the explanation in the memo at para 1.
Para 1, please, my lord.
Office objection at C number 1 is overruled.
Please, my lord.
2.
My lord, 2, I will, that is just one signature is missed out. I will just sign that, my lord. And 3, how the respondent numbers 3, 4, 6 to 10 and 13 are made parties in CMP when they are not parties in the agreement. But they are parties in the agreement, my lord. That agreement is there at Annexure A. It's only that since they were minors,
the natural guardian has represented and signed, but now they are majors, so they have made parties.
Page,
My lord, page number 23, annexure A.
who are those?
My lord, in this,
Huh.
serial number 3, Ravi N, aged about 42 years, as father and natural guardian of minor daughter Kumari Sheetal, 10 years, and Master Shreyas, 8 years. So all those children who were 10 years and 8 years as in 2006, now in 24, they are all majors. So we have made them parties. They have not signed it, but they are already represented as natural guardians.
This objection, see number 3 is kept in abeyance in light of the explanation made in the memo. Yes, then
And then, my lord, at serial number 4, why Mr. S.A. Kabir has not been made party? When he was a party in the agreement dated so and so to be clarified. Now, page 24, my lord, of the same agreement. 23, my lords, just so page 24. He has acted as a director in the representative capacity of the petitioner company. So he is not individually a party for us to make him a party. Another director is represented in the CMP.
in light of the explanation at para 3 of the memo file, office objection seal number 4 is kept in abeyance. Court fee.
It's paid, my lord. It's annexed along
counsel
with the
for
memo,
petitioner submits that court fee has been paid.
and it is annexed to the
So
memo.
far as office objection seal number 2, petitioner is permitted to comply with the same forthwith. What is it now?
My lord, notice is that,
The clause is at
my lord, my lord, page number 47.
now the notice
Notice is sent and they have replied also, man.
replied.
They have replied. Notice is at page number 87, my lord.
Yes, reply.
And the reply is at page 120. There were 2 replies. In fact, they say that we can alienate. It's at page number 120, 119 and 120.
Notice.
Obliged.
Deepak DC, 17,
Weeks time granted for necessary compliance.
18,
My lords, I appear for the petitioner in serial number 17, my lords.
Yes,
My lords, I kindly seek for a week's time,
yes, weeks time granted for necessary compliance.
please. Serial number 18, 19 is also the same, my lords.
Same order.
Please. Much obliged.
Petition 1 week time NSC ಬಂದಿದೆ ಈಗ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
Weeks time granted finally for necessary compliance. Relist the matter on. List, relist. Relist on.
22, seal number 22, Rajshekar.
Lords, the address of the respondents are, my lord, some are in Delhi and some are in Telangana. That is why, my lords, 138 proceedings is pending before the trial court at Udupi. So I may be permitted to serve on the council representing the parties before the, my lords.
Petitioner is permitted to take out notice through court apart from serving counsel for the unserved respondents who appears for such of the respondents in
my lords, the magistrate court at,
File a memo.
I'll number.
file a memo with the details.
Yes. And also, my lords, I may be permitted to take out hand summons also, my lords, so that it will be easy.
Petitioner is also at liberty to take out notice by way of hands.
Please.
Yes.
4,
That is with regard to the last date I submitted with regard to the calculation, it can be gone into by the arbitrator. Now the clause is, let annex A page 11. It's a sharing agreement. The clause number, let your lordship will print it, page 20. Page 20.
Yes.
Let the arbitration, your lordship.
Now, what is the dispute?
Dispute is with regard to the sharing, construction and the sharing agreement. There is a dispute.
You have any objections? Have you filed?
No, they have filed, their objection is renovative agreement have been entered into. But I have filed a AA proceedings. In that, we have taken that it is a concocted agreement itself. That part of the dispute can also be gone into by the arbitrator. Kindly similar to the AA proceedings under section 9. Let page 31. Page 31. It starts from annexure B, page 24. Kindly turn to page 31, para 12 and 13.
Even that can be kept open.
That can be gone into by the arbitrator.
That
ಅಲ್ಲಲ್ಲ admission ಗೆ post ಹಾಕ್ಬೋದು ಅಂತ ಆಗಿತ್ತು.
both questions can be kept open to be decided by the arbitrator. Now, stamp, it's a settled procedure that it can be done even at that stage. In case of the others, now this question whether that agreement supersedes or not is also to be decided by the arbitrator. If the arbitrator were to hold, no, it is genuine, it's binding, then his arbitration goes. Because arbitration is now on the, by invoking the earlier one. So you come ready with, relist the matter on. It's a very limited jurisdiction. So all that you can raise there.
Please.
25, but there's one short objection in the amended cost title. The company representative name is wrongly mentioned. I shall carry it here. Said, no, my lord, the opposite is served unrepresented. It could be considered. That amended, I shall carry it. It's a case of annexure, page number 12. It's a retail partnership agreement. Annexure, page number 12.
Dispute between?
Between, my lord, the respondent number 1 and the petitioner. My lord, the petitioner is, my lord, the Metro Brands Limited. Page 12, it's the agreement.
Yes.
Lord, the page 11, my lord, the preamble portion, my lord, the page annexure, page number 11. Lord, the Evolve Business Ventures is the respondent number 1, man. And Metro Brands is the petitioner. My lord, the Evolve Business Ventures, my lord, was given, entered into a master consignment agreement with the Airport Authority of India at Chennai. Page number 14, my lord, there's one, there is a mention. My lord, the Airport Authority of Chennai given, my lord, a outlets, a shop, my lord, to the Evolve Business respondent number 1. My lord, he has sublet it, my lord, in a retail partnership, my lord. That page number 14, my lord, the unnumbered clause A, my lord. Lord, it says last 2 lines. So, award letter dated 12/7/2018. The airport authority gave the outlets to the respondent number 1. I'm Lord, they entered into this retail partnership agreement by giving that shop to me, man. I'm the Metro Brand shop, my lord. So the dispute is that, my lord, the master agreement was cancelled by the Airport Authority of India. And then, my lord, they said you entered into a new arrangement with me. Because of this, my lord, we requested to refund the security deposit of 18 lakhs, my lord. The first communication, my lord, clause, my lord, the clause, lordship find it article 13(1)(3), page 28, my lord. The bottom, 13(1)(3). 13.2 is, my lord, the arbitration clause. Before to that, there's also, my lord, we have to go for cancellation. I showed that notice, my lord, they did not reply.
Yes.
Please, my lord, the first communication, annexure D, page number 47. Annex ID 47, unnumbered para 2, my lord, we inform that the unnumbered para 2, my lord, in this, my lord, we inform we received an email dated 15/2/2022 from Airport Authority of India, wherein AI has conveyed to us that the license given to you under the master concessionary for the retail outlets at Chennai Airport dated 12/7/2018 has been terminated with effect from 16/2/22 to 22. AI has further directed to enter into a new arrangement with them with escalation charges. My lord, the bottom last para, we said, my lord, we please refund 18 lakhs the security deposit. My lord, this was untenably replied. And later, my lord, the arbitration notice at page 65, annexure J. This was not replied, thus served.
This was
Annexure J, page number 65. This was served, my lord, they did not reply. The postal track report, my lord, at annexure J2, page number 70. It is delivered. And there is a conciliation notice also we issued, my lord, as per the clause annexure K, page 72. Even for that also, they did not respond. Meantime, my lord, we learned that, my lord, his business has been transferred to the respond number 2. We have been implemented, my lord, respond number 2. So both are necessary party. Respond number 2 is not a party, but we learned that, my lord, business has been transferred. Respond number 2 was also
correct,
issued.
but now you are only seeking for refund of 18 lakhs.
Please, security deposit.
For that, the only person is the person under the agreement,
Please,
isn't it? So you would confine it only to the parties to the agreement.
please, my
Now,
lord,
the agreement is between you and the respondent.
please,
Now, the respondent has to pay you 18 lakhs.
please.
So it is essentially a proceeding for recovery.
Please, it is a recovery. Well, now we learned that there's a transfer. Well, recently, we also gone through one Delhi High Court judgment.
Who's the second respondent?
My lord, second respondent is a travester. My lord, who has been, they said they entered into business transfer agreement. So, my lord, even they also not replied. My lord, there is communication to that respondent too also. They have not replied. In future, my lord, they are not represented. Then, my lord, the one judgment I gone through from the Delhi High Court is that, my lord, the learned arbitrator has no power to either implead or delete. So whatever has to be done, it has to be done before this honorable court itself.
No, correct. Now the obligation to repay your 18 lakhs
Please,
is by Evolve Business Ventures.
Evolve Business.
According to you, Evolve Business Ventures has been taken over by this.
Please, my lord.
That's your submission.
That's a submission.
But then you'll have to give some material.
Well, there's one agreement, my lord. I just, I'm sorry, my lord.
You check, you make a search in the registrar of companies.
Look, there is one agreement. I have the copy. I'm just sorry, my lord, with there is no memo. What's it may reserve liberty, my lord, in the event if the respondent number 1 comes and says it before the arbitrator, saying that I have transferred the business, I have no role to play. In that event, my lord, respondent number 2 be prosecuted.
So just now you take me through this agreement.
Please, my lord. I have the only one copy, my lord. I'm sorry.
They've sold it.
Please,
They've sold it.
my lord, they say, my lord, there's been transferred everything.
Petitioner has sought for. Even they have also been served.
So both of them served, my lord, they did not represent.
The IA was allowed.
IA was allowed.
The petitioner has. sought for appointment of sole arbitrator in light of by invoking clause 13 of the agreement, which is styled as a retail partner agreement entered into between the petitioner and the respondent. It is submitted that the respondent is said to be a concessionaire appointed by the Airports Authority and is running a business. It is further submitted that disputes have arisen between the petitioner. Now,
Please.
the concessionaire, that is Evolve Brands,
Please,
has entered into an agreement with you.
with, please, he's entered with me.
In between
The master,
the concessionaire by the Airports Authority, full stop. Hello, beta, full stop. In light of the space granted by the Airports Authority to the concessionaire, the respondent has further leased out that
please,
portion of property to the petitioner hearing.
please.
Further submitted that certain disputes have arisen between the parties under the said agreement, and the petitioner has claimed for refund of a sum of rupees 18 lakhs.
18 lakhs, 1/8.
The said agreement is produced at Annexure A, and the clause for dispute resolution through arbitration is found at 13.1 in under Article 13, which is sought to be invoked. Full stop. Clause 13.1 provides for amicable negotiation. 13.1.1 provides for amicable negotiation and conciliation. And if there cannot be resolution by such process, the matter to be resolved through arbitration. Clause 13.2.1 provides for resolution of disputes through a sole arbitrator. The petitioner has contended that the respondent, Evolve Business Ventures and another, has been taken over by virtue of a business transfer agreement by Travstar Retail Private Limited. Full stop. Copy of the business transfer agreement is filed along with the memo. It is further submitted that in terms of clause C of the said agreement, transfer has been made as a going concern, in light of which the second respondent has been arrayed. You don't have the entirety.
Please, that's only short.
the counsel for the petitioner submits that he has only a portion of the said agreement, which is produced along with the memo. Further submitted that it is necessary that the transferee also is required to be referred for arbitration in the present proceedings as well. It is also submitted that a demand has been made
Annexure
efforts for resolution of a dispute by an amicable process having been failed, petition be allowed. There is the agreement between the petitioner and the respondent. Clause 13 provides for dispute resolution by way of amicable negotiation and conciliation, followed by arbitration. Insofar as attempts for a negotiated settlement is concerned, this same is evidenced by
But the negotiation is failed, my lord, but there's a conciliation notice we issued at annexure K, page number 72. 72. So for which they have not replied for conciliation.
is evidenced by a conciliation notice at annexure K. Now that was served,
Please, it is served, my lord, annexure H,
served as evidenced at annexure
K1,
K1.
please.
It is only subsequent to this that another notice invoking the arbitration clause.
No,
has
see here, first we issued arbitration notice, then we realized there has to be a conciliation. Then, my lord, conciliation issued. The arbitration is issued first, my lord.
been page
Page 65, annexure J.
annexure
J, my lord, 65. 65.
this has been served.
This is also served, my lord. Annexure J2 is the postal track record.
in the thereafter, madam. It is also noticed that a legal notice at annexure J dated 1/6/2023 has also been addressed to the respondent invoking the arbitration clause. And the same has been served as is evidenced at annexure
J2, my lord,
J2.
70 page number.
Annexure J2. Which is the postal track report. Full stop. The submission of counsel for the petitioner that though the notice for negotiated settlement through conciliation was issued as per annexure K subsequently, no prejudice as such has been caused as the respondents have not responded to the offer for a negotiated settlement at annexure K and the notice for arbitration at annexure J, though issued earlier through to annexure K, can be accepted as sufficient compliance of the requirement under Article 13. In light of non-response to annexure K and J, despite service of such notice upon the respondent, submission of the petitioner requires to be accepted, and mere issuance of notice invoking arbitration clause prior to the notice for conciliation ought not to defeat the right of the petitioner. In light of the facts as made out above, including of the agreement at annexure A, the clause for dispute settlement found in Article 13, comma, legal notice for conciliation at annexure K, legal notice invoking arbitration at annexure J, and that both notices have been served on the other side. Petition deserves to be allowed accordingly ordered. It's a small claim, so we can, we'll appoint
Honorable-
somebody on the same terms of the center. It may be held outside. Center, they don't have much space. So I'll see how, what it is. We'll share the name with you and then we will.
I had a name, my lord, Lordship's permit.
Correct, but the only point is, since it comes from you, tomorrow they may raise some objection, but I'll consider it.
Please.
Or somebody instead of that on same terms.
Please,
The name that you're suggesting, the notice.
please.
Name that you're suggesting, the notice. is it?
Notice, no, my lord, the outside, my lord, the Kukaja Ramakrishna Bhatt sir is also doing, my lord, so his name, my lord, the outside we.
Let us see, I'll consider.
Please, sir, obliged.
But it will be ad hoc then, yes.
Please.
Let us.
56.
Be listed after service of notice. I request a shorter date.
Office to put up a report regarding notice issued to R1 and R2. 21st. Next.
27. 27.
Date of hearing, notice was ordered through court and also through email. I have taken steps through court lordship. I have paid the PF and other things. As far as email is concerned, I have sent the email from my personal mail of my advocate email ID and also my party's email ID, and also I have sent the WhatsApp message. But the office objection is it has to be through registry. Lordship, if the date may, if it is fixed, I will get it notice issued through registry
It's
also.
in electronic mode to be done through the registry.
Registry. And one more thing, lordship, they have in the memo have given email ID of all the except respondent number 2 and 3 have given email ID of all the other person. 2 and 3 I don't have the email ID. I have the WhatsApp only. Therefore, they have raised the same objection.
Petitioners permitted to take out notice by way of email through the registry insofar as respondent number
Two, lordship. One, yeah, 2 only.
2.
One I have given the email ID. I have the email ID of respondent number 1. 2 I don't have the email ID.
Notice through email to respondent number
1.
1. The petitioner to furnish necessary email IDs to which previous email communication has been addressed to respondent number 1.
1. 2 I don't have it, lordship. 3 is already served.
R2 you want to take through WhatsApp.
WhatsApp, lordship.
Petitioners at liberty to take out notice to R2 through WhatsApp and file necessary report regarding service of the same.
Same.
3.
Respondent 3 is already served, is not represented. Notice is served. One more thing, lordship, respondent number 2 is a company represented by respondent number 3 only.
No, that may be so, but you finished 2 also.
Yes, will do.
List, relist on.
20.
25, just original may be written, direction to return the original.
29.
Week's time granted to do the needful. Time granted for necessary rectification of Wakala.
21.
Lord, 3 objections. And I have filed the application for dispensation this morning, my lord, in the registry. So far as objection number 1, my lord, is regarding arbitration clause has not been mentioned in the prayer column.
You have filed a IA for dispensation.
Yes, my lord, this morning in the registry I filed.
Okay, then you complete it. I'll have it next.
Please.
The order directing that
The
petition
third
shall be-
objection may kindly.
petition shall be listed for dismissal is recalled in light of the submission made by counsel for the petitioner. Petitioner to comply with the office objection by the next date. Next date. Full stop. Insofar as office objection at seal number 2, petitioner submits that the application for dispensation of production has been filed. Office to put up the same. Relist the
Third one may
matter-
be removed.
Relist the
Third.
matter on.
The
8th of
third
March.
one, my lord, is only classification of case that does not apply here. There is no classification. The third objection the registry has raised.
ಇದೇನು ಮಂಜುನಾ? ಇದು CMP ಅಂತ ಬರಿಬೇಕು, CMP ಅಂತ ಬರಿಬೇಕು. Okay. That you have to write it somewhere, just that once they require, we cannot go beyond what they say. Yes. Next.
Question 32.
Yes.
My lord, in this matter, I will have to, before that, I wanted to read the agreement.
Page.
Agreement in the next game. I kindly look into the,
Just 1 minute, just 1 minute.
condition 7. Here, next year, agreement to sell.
Page.
Not dated to 16 July 2014.
Yes.
Page, my lord.
Yes.
Agreement to sell. Annexure A, my lord.
Yes.
That agreement to sell dated 16 July 2014.
Yes.
That is, we'll go to the para 7 of the conditions. If the vendor, may I read to your lordship?
Page.
Condition 7, my lord, sorry, my lord, not able to noted the page.
Roman 7.
Oh, agreement to sell.
If the vendors fail.
7, condition 7 of the agreement. If the vendors fail and are neglected to complete the sale after the title being made out as aforesaid or otherwise to carry out any one or more of the obligations on their part as hereunder provided or otherwise required by law, the purchaser will be at liberty to enforce specific performance agreement by institution of a legal proceeding or at his option may sue the vendor for recovery of the earnest money. The second condition, if on the title being found good and marketable, the purchaser failed to complete the purchaser within the time aforesaid, the earnest money shall be forfeited to the vendors or their vendor may at his option enforce specific forms of this agreement by the purchaser, and the purchaser will also be liable to pay costs and expenses within. Then dispute resolution. Subject to applicable laws, the vendors and the purchaser shall negotiate in good faith and use reasonable effort to settle any dispute, controversy or claim arising from or related to this MOU. In the event the vendors and purchaser are unable to within 30 days reach the resolution, such suits will be referred to the mediation to a mutually acceptable senior counsel with Karnataka High Court, who shall attempt to, in good faith, to reach the resolution of in dispute. Next, my lord. If the foregoing proceedings fail to achieve a mutually satisfactory resolution within 60 days, then either the vendors or the purchaser may by written notice to the other elect to have the matter settled by binding arbitration in situation wherein the above mentioned steps failed, such dispute shall be referred to binding arbitration and the Arbitration and Conciliation Act 1996 and the rules made thereunder as mentioned in force from time to time. I will stop this one. But as per this agreement of sale, the vendor herein went to the civil court for special performance of suit. As per the special performance suit, this notice was ordered and placed ex parte. Decree was made in favor of the vendor. The decree in question passed against the purchaser, vendor, in favor of the vendor. Then against that, it is placed in ex parte, the purchasers. Then against that order, my lord, judgment and decree, they have filed a writ of RFA before this honorable court. This honorable court remanded the matter to fresh consideration before the civil court for fresh consideration, set aside the judgment and decree passed before the vendor. My lord, when the matter was remanded to the trial court, at that time, my lord, when the matter was remanded, and ಆಗಿಲ್ಲ Sorry, my lord, I could not able to weigh out. Now only 2 copies. When the matter was remanded,
Yes.
when the matter was remanded, the purchaser filed an IA number 3 under section 8 of the Conciliation Act.
That was allowed.
That was allowed. Then the lordship, I wanted to read the portions of the order. The lordship
Now
permit.
that's admitted.
It is.
So now you have sought to invoke.
My lord, in this matter, I wanted to read the order. In page 13, madam. For the above judgment, it is clear that agreement of sale does not involve any transfer of right in rem. Therefore, the claim for specific performance are arbitrable and can be referred to arbitration. In the present case, the suit is for specific performance and it creates only a personal obligation. Hence, it can be referred to arbitration accordingly as concern must know. A number 3, filed by the defendants under the 8 of the arbitration consideration hereby allowed. Both the parties are referred to arbitration. Office returns the plaintiff to the plaintiff. And thereafter, my lord, I issued a notice to him when the matter was over. Then you notice may kindly be looked into, my lord. I issued a notice thereafterwards in the annex to the CMP petition. My lord, ink I could not able to, page I have not noted in my paper. Legal notice issued on 7/9/2020, my lord. 7/9/2020, my lord.
Yes.
My lord, I narrated all those things, my lord. You will ask me kindly. Para 4, para 5 of the legal notice, my lord. When you fail to fulfill your part and of the obligation under the agreement, notice was issued and thereafter my client filed a suit 4252 on the file of the Executive Court. The said suit was contested by the yourself
just
and a
1 minute.
decree came to be
Just
passed,
1 minute.
which was upheld.
Just 1 minute. Now, what is your objection now?
Third objection is
Third objection is?
barred by litigation. Agreement on its face of it.
Okay, so now insofar as the stamp duty is concerned,
They are paid some. The judgment is that
insofar as
the document is not registered.
some authorities state that since the arbitration clause is a standalone clause, the even if the I think 11 itself says it is a standalone clause, so that can be treated as an independent contract.
Not stamp duty, my lord.
No, I'm saying registration.
Registration also not kindly feel. This document, the document itself requires registration. Turn to
Registration actually. Registration.
para 6 of the transfer of property. Kindly read this clause. Taken possession. Chaser is supposed to be acted in possession. Inducted in the also deliver vacant possession. Under this agreement, the purchaser seeks to claim possession over the
Just one arbitration. In some judgment, let me just check.
judgment of the Supreme Court stamp as
No, on registration.
on registration also, the document cannot be accepted even for sending it in view of the registration. It's a compulsory registrable document.
We'll just have it next week. There's one judgment. I'll ask the court officer. I've just come across. Let us have a look at it.
Yes.
On the point of registration.
Yes, the only thing is transfer of property. No document can be enforced because until it is registered. And if you say on the date this agreement, if you deliver possession, the document requires not to look into at all, even in the section 14 or under section 53A of the. Therefore, it is a compulsorily registrable. The third point which I raised is not Article 136. Date of the agreement is 16/7/2014, and the notice is given in 2019 after 5.5 years. But the Article 137, the three judges bench of the Supreme Court says, on the base of the document, even in CFP proceedings, the matter cannot be affected.
He's saying after the order of the trial court.
That
it must
section 14, section 14 here may not, because the document will have to be read on the face of the document. It does not go to the court.
You examine these points.
I am having regarding the 14, section 14, Honorable Supreme Court says, in view of that thing, if anything done in other court, may read your lot, section 14.
But in the context of section 11, they are saying it's not applicable.
No,
Section 11.
on that one is I am having a Supreme Court judgment. On that having only regarding Supreme Court judgment.
40.
They read your lordship section 14, excuse your time. I don't want to read this one.
No, that, yes.
14 of the limitation.
The first judgment. But before that, one prima facie observation that it should first go for conciliation and amicable resolution.
That is exhausted.
Yes, which,
My lord, you reported in 2021-7. Only I am reading the head notes. I don't want to go. Insolvency and bankruptcy, section 14 of the Limitation Act, for exclusion of time, proceedings bona fide, wrong court or forum held applicable to applications preferred under section 7 IPC. Once it is shown that all conditions for application section 14 of the Limitation Act are satisfied in the facts of the case, use of the expression so far as may be relevant. Then you portion, my lord, you will also make see held ಕೆಳಗಡೆ. The words as far as may be cannot be construed as a totally exclusion of the requirements of basic principle section 14 of the Limitation Act, but permits a wider, more liberal, contextual and purposive interpretation by necessary modification, which is harmony with the principle of the said section. Limitation 86 applicability IPC proceeding, words and phrases as per termination of wrongly persuaded proceeding, not essential for claiming exclusion of time of the Limitation Act. Exclusion can be claimed even while the proceedings in wrong forum are pending. Then you are he had not he. 5 and 14, principle of 14 for the condonation delay, applicable section, sufficient cost, so and so is applicable. Then second judgment, my lord, you will also make page 40 minute, 40, Supreme Court judgment. Section exclusion of time spent proceeding must relate to same matter in issue. Appeal is allowed. Then in page 42, Miller, Supreme Court judgment 216 per 3, head note B, Miller. 114.3 explanation A, exclusion of period of spent bona fide prosecuting proceeding in wrong forum, entire period from institution to wrong proceeding until it was ended, disposal, it is held excluded as per 14.3 explanation. Fact that proceeding concerned had become non-maintainable, non-maintained as hence before wrong forum due to declaration of law to that effect by Supreme Court during pendency proceeding, effect of delay in getting wrong litigation disposal of explicitly by litigant, duty of opposite party to have got litigation disposed quickly any period of such a day, it can be excluded considering is bona fide. Then you will also the another judgment, my lord, next page judgment.
now under this, it's extended even to 11 proceeding.
Then reported in page 76, my lord. That is also a Supreme Court judgment. Page 76, my lord. Time, only I am reading the head note. Time spent for in proceedings bona fide in a court without jurisdiction, the exclusion of under section 14 in consumption period limit scope, whether the period of spent in pursuing the petition should be excluded while reckoning the petition. Then we will go to the Swalpa Kelagade. Words, other cause of like nature to occurring, true purport of indicator, words and phrase, others like this. Then the next judgment, our own High Court, page 96, my lord. Applicability, section 14 and 15, applicable dispute as to allotment of bonus shares between the transferee and shares company, prosecution before wrong forum, even prosecution before consumption forum is bona fide prosecution for purpose of section 14. If so, a different view cannot be taken for purpose of section 14. Hence, the provision are applicable. Company Law Board ought not to have rejected the application on the ground of delay. Then you will also kindly go to our own High Court judgment following the other Supreme Court judgment in page 138. In page 42, you will also be kindly see. Single judge judgment. Further, in the case of Srimati Lata Devi so and so, section 14 of the Limited Act does not speak delay, but is specifically only exclusion time required for proceeding before the trial court. The proceeding must be held, have been terminated effectively only when the plaintiff he was ready for handing over the plaintiff presentation of the proper court. It was so. 18 forthwith admittedly enough was presented before the proper court on the very same day without delay. My lord, on the basis of this judgment, my lord, if you look into the Order 7, Rule 10 of the CPC, if any petition is returned to present it to the proper court, on that basis, when there rise an objection by the defendant, the trial court permitted to file an arbitration, go before the arbitration proceeding. Hence, the question of delay does not arise in this case. And also, in the agreement of sale, it provided specific requirements, go to the civil court as well as the arbitration class. When they have raised an objection before the civil court, the civil court return the plaintiff to present it before the arbitration. There is an arbitration class. The question of delay does not occur in this case.
On the point of registration,
I want to look into that when I will submit regarding that aspect.
relist the matter.
Regarding that registration, I will look into that and submit regarding one on that aspect.
But then that may be a matter to be left there to be decided, whether it's bona fide or not.
And 6 only says, yes, okay.
But whether it's bona fide or not, we leave it to the arbitrator to decide.
That I convince the court on. Now, regarding the judgment on which relied on my learned friend, you may look into that judgment, the recent judgment of 3 judges. In that also, the Lord's may kindly. Ink page, my lord, your Lord's may kindly look into the para 72, what my learned friend relying on the judgment. Para 72 to the judgment. Para 72 nali.
Para
72 minutes. Para 72 alerts.
really mention. Check it. Huh? Really. Okay. जाऊ दे, ये तो कुछ नहीं.
Para 72 regarding section 5 to 14, whether it is applicable or not ಅನ್ನೋದು ಹೇಳಿದೆ.
Sentence in that. 5 to 20 of the limitation, unless there is a pleaded case specifically adverting applicable. How we can date on the cost. Generally, there can be basis to say that. It's important.
You have not made any pleading.
Huh?
You have not.
Regarding that aspect of the matter, the learned judge says that 5 to 14 is applicable for present case.
There's no pleading here.
No pleading in the sense, my lord, you will also make it what my learned friend says. On the face of it, look into that, look into the regarding, they went to the civil court as agreement provided. On that basis, I issued a notice. Issued a notice saying that I spent time in the civil court. Hence, I issued a notice after return of the plaintiff. The question of pleading does not arise in this case because the notice was issued. In the pleadings also I mentioned. In my CMP petition, para 6 of the CMP petition, para 6 of the CMP petition. Para 6, when the respondent failed to fulfill their part of the obligation under the agreement, notice was issued and thereafter suit 4252 filed.
The said suit was not contested by the respondent, and decree came to be classified by the assigned by the respondent RFA, which came to be allowed on 22, and the matter remanded for consideration. Thereafter, the respondents have filed an application yet at the Arbitration Act invoking arbitration respect to the agreement dated so and so, which came to be allowed by the citizen court, and that the Honorable High Court pleased to pass an order, return the plaintiff with the direction go before the
Let us
court.
see.
On that basis, I came up before this court.
Relist
I issued a notice and came up before this honorable court.
On registration, you make a submission.
Registration, I look into that, I submit.
Relist the matter on 12th,
Next week. Date when?
12th. ये बाकी तो नहीं है। Tuesday दिया है। हाँ, वो Tuesday लिखी हुई है। I'll have to go back to my first list. So other matters of this list will be, dates will be given on Tuesday and Wednesday. Tuesday and Wednesday. 30?
Yeah.
You want? 30.
33? 33?
Petitioner to serve copy of petition on counsel for the respondent. Yes.
39, we're in agreement that arbitrator may be appointed. Only thing is I want to keep open all my contentions. I'm for the respondent. I'm saying that the arbitration agreement itself doesn't apply, including the question as to which is the arbitration agreement. I am contesting that the document on which they are relying upon for the arbitration agreement. I have offered arbitration under a separate notice. The CMP has come to be filed. Either way, both of us are in principle ready for arbitration. The question is under which document? Let the arbitrator decide.
We'll have it on Monday in the orders list.
Grateful. And Justice A.V. Chandrasekhar, we are both agreeable. Please.
16.
Release the matter 39 in the orders list on Monday.
Grateful. Please.
69, my lord.
Yes.
69.
At the
Fifth
top
or
of
seventh?
this list. Top of
Fifth
the-
or seventh? 69, serial number 69.
No, dates the court officer will give.
List number 1.
My lord, second list 38, my lord.
Dates will be given. Any other?
Not date,
mentioning-
my lords.
No, correct. Which matters which are not reached, Tuesday and Wednesday dates will be given.
Please.
Any other submission you make?
Much of it.
My lord's cost list number 2, serial number 37.
Serial number 30.
37, my lords.
Just 1 minute, wait. Dates will be given by the court officer on Tuesday and Wednesday. Yes, first one. First.
Serial number 12, pardon me, other repeat. Serial number 35. 12th of 30.
Which list?
Second list, 35. 12th of 12th of 30.
35.
35. No, not for argument, not for the argument. We have continuously submitted that we don't want arbitration, we will settle the matter. Possession has been handed over and we have given them an amount, which they say needs to be amended. If the matter is mediated, then without arbitration only they will be paid. We do not want to be. We have offered them along with the statute.
No.
Not available.
Correct now.
Speaking for the 12th.
We are going to, he's saying it can be settled by way of mediation.
Yes, please.
If it is okay with you, we can refer it for mediation.
No, I'm not denying payment. I will pay. Let it mediate and arrive at an amount of the only.
We'll appoint a mediator.
Grateful.
In light of submission of both of the petitioner, that matter could be settled by way of mediation. And the counsel for the respondent submits that they have no objection for such suggestion.
I'm
The counsel for the Please stand in the counsel for the respondent submits that the matter may be referred for mediation. Counsel for the petitioner submits they are not averse to such a suggestion. In light of the same, matter is referred for mediation. I'll appoint the mediator.
Master matters. Next one, serial number 12, Sagar Baby, Pawan Kumar.
For the petitioner.
Yes.
Notes the order impugned notes is at page number 122, annexure M by virtue of.
Pawan Kumar.
Notes he was here, my lord, sir. Twice it got passed out.
You had come.
Notes he was here earlier, my lords. I have intimated him, my lords, that the matter was passed over.
Just it will take it. Or it's not. Call him telephonically.
Yes, yes. I'll inform.
Pass over.
14. 14.
Relist the matter on no representation on behalf of the petitioner. Relist the matter on
15.
no representation on behalf of the petitioner. Relist the matter on
48.
Petitioner. There. The impugned order is not passed by the competent authority, Your Lordships. KPTCL. The order has to be passed by the
letter come. Pass over.
pass.
HK.
Yes. A small recap of the rest. In terms of the point number 3 to the post consulted. This falls under the current field. And the petitioner has filed of PC. He cannot, he doesn't have a letter to question the court is not filed. He has taken a contention that since the university has shortlisted him, it's not open for the on now to consider. Open 20 roughly how much time will require, so I can at least ask the others that if it's going to take time, we will ask, we can discharge the remaining board. Other councils who want dates can take it from the court officer, except the passed over matters, other matters are not likely to reach. Any submission you can make, you want to make, you can make at the end. Dates will be given by the court officer.
One of the issue because when we read rule 6, at what point of time the case is to be factored is one of the dates we look to. It is 29 years. Because the we have taken this charge of the case on 30 cases of the this seems to rely on the and the response within the only basis whether whether it should be to him in terms of cases. In this way, the name here in the brief is related to university and the university of the under rule 7 of the state and on the to the portion and rule 6 cannot be and is working with reasons
We'll just have a look at rule 6 and 7.
from among the candidates who have applied in person, writing applications
And taking into consideration the differences and shall also be included in the selection of notwithstanding anything for the company contained need for recruitment or need for this support. The recruitment and the recruitment for the company. Selection process for all to invite and more than one of these consent clause 3. Notwithstanding anything to be contrary, anything in the Karnataka city and for recruitment of these or both the police must have attained the description of the rule. Karnataka is provided for when the east of selected immediately appointed by the appointing authority after such inquiry. According to the date of notification was considered in April 2003. For making an 21/4/2018 was the last
20?
21, 23, 2018.
Last date for?
Making an act. So it's one of the issues that will arise for your consideration. Whether the cutoff date the purpose of applying rule 6, or whether it is the after the lease is drawn. Because I was immediately shocked the time of the last date for making application by 40 days for a month and
You are saying that the operation of Rule 6 will come at a later stage.
yes, because after the lease is drawn, after scrutiny, which happens after 1 year. So it is at that stage that the appointing authority will have to factor in. This submission which I'm making is independent of my main submission. That if a person is not eligible academically, question of he is being preferred in terms of Rule 6 doesn't arise. And in the absence of any other person more age than me, I'm still entirely to be appointed units in terms of Rule 6 itself. So the pattern of this preference arises after the least is preferred. Rule 7 says persons whose name is included in the list prepared under Rule 6. So Rule 6 preparation is an event which, according to me, is the relevant date for the purpose of applicability of the preference rule under Rule 6.
We are saying even if a list is prepared under Rule 6 prima facie, the subsequent order of appointment can be made only after they inquire into and satisfy themselves as regards suitability.
Yes. Let's say if the authorities appointing fine, even after list is prepared, that somebody doesn't qualify.
There ends the matter.
Then, my lords, applicability of Rule 6, preferring him merely because he is in the list of applicants or who are found to be suitable by the committee at that stage. It is only at the stage of appointing or at the stage of preparing a list that the question of applicability of this arises. In fact, in the judgment which my mentioned has been relying on. Judgment makes a reference that this applicability used to learn the application for this.
Yes.
Page 24 looks part of the judgment. The risk of repetition notes I'll point out. This case did not go into the academic eligibility of law. Because it was both were eligible and was for the Department of English. Special rules which deals with the manner of preparation of mandates that the selecting authority after the list of eligible candidates is out. Selecting authority after the list of eligible candidates is out shall consider the appointment of the candidates who are found eligible and who are between the age of 29 to 40. If no candidate is available who is eligible to be considered for appointment to the post, it is then the selection authority would allow the right to consider candidates who are between age. Therefore, the authority has to first prepare a list. And I have this question myself.
Page?
Page 25. Petitioner in that case. Page 34, while the person was selected was 25. For the court found that when you draw the select list, you could not have selected person age 25. The person with 34 age was also there in the selection. That's the rationale in the assessment. The fact remains here that the process then merely calling for an application is factored in Rule 7. It has to be understood in totality. At what point of time the whole rationale in providing for this Rule 6 is that a person who has crossed 30 will have a lesser opportunity of being considered or appointed. And the person who is less than 30 can still await a fresh application, though everybody between the age of 18 and 40 is eligible, provided he has to prescribe academic qualification. And that's the purpose in providing for this special. No problem with that proposition. Person who is required to be appointed, provided he is on the same footing as the other person. Here, there can be an unequal compared for the purpose of application of Rule 6, because he suffers basically the qualification which is prescribed by the advertisement or by the provisions under the UGC.
You're saying age cannot substitute eligibility. Age cannot substitute eligibility.
It can be. There is no problem with that issue, not that he is more age than me, or he is aged about 30 and therefore he would have this priority. But priority arises only if he is eligible. Now his prayer is to appoint me in his place. There is no person who can fit into any of the subject which is taught in the institution for which it is being reviewed. Point out that the person who doesn't have the requisite qualification can't come to the court seeking for the discretionary relief at the hands of this honorable court to appoint him applying Rule 6 of this rule, saying that he has been wrong in the past. When we come back to election and submission, the notification calling for application for various faculties clearly stipulate mode of selection to be prepared by following DPAR order dated 21/11 and 2000. As well as UGC regulations 2003, UGC, Fourth Amendment 2016 and AICTE 2003 regulations. Such being the case, there cannot be consideration beyond the UGC regulations that stipulate under heading 3.0G. Recruitment and qualification also item 3.1.0 that contemplates merit. Of the petitioner needed and
What is this para 30? No, what is the point in para 30?
30 says you can in isolation consider only Rule 6, because the notification said appointment will be in accordance with the special rules laid with UGC regulations as well as AICTE insofar as engineering departments are concerned, as well as the DPR directions in terms of those executive orders.
Yes.
When you read as to how you proceed further in making an appointment, there is a process involved which is not questioned by the petitioner. He has undergone the same process I have, and he has acceded to the process that involved in making this appointment. Now, the case of the petitioner pleaded in contention base focus and revolves only on the issue of age criteria in selection process, in selecting candidates, for stipulation under Rule 6 of the rules, containing that he is aged 32 years and whereas this response is 28 years, 10 months and 13 as to date, on the date of making of the application. In response to advertisement by the university, inviting application and in terms of said rules, is to be preferred in drawing up the list of selected candidates. So the question is whether it is a cutoff date which requires to be factored in when we consider the case under 6, or when the merit list is drawn by the authority. So there's immediately a gap of more than a year and a half by the time the application was invited and interviews were conducted. The appointment comes much later in the can be noticed. The special recruitment rules, annexure A, among others, by Rule 3, provides us the prescription of eligibility criteria. Age candidates for recruitment to any service of post attain age of 18 years, not completed to years. Under Rule 5, it is provided for more process of consent rate to be made by the selection of the causing to invite applications and candidates academy by publishing an official gazette and newspaper. It is under Rule 6, under the heading List of Selected Candidates, that the procedure for drawing up of merit list among the eligible candidates is provided. In other words, it is at the stage of so drawing the merit list, it mandates candidates in the age group of 29 to 40 years, the first round, listed, and if there is insufficient, then the merit list of candidates of age group of 18 to 20. That's a rule. And six are a specific. This rule that is being pointed out in the as having appreciating the selection and encouraging him for consequences. Here, it is submitted. State recruitment to settle for the petition, including description of and connected to it. Note including to assist the state rule that provides for prioritizing and choosing candidates in the age group of 29 to 40 after the easy application. One of the corrections of appointment and the state rule not this position is not however it is not a in-person case as the petition is not in for appointment to the notified court. Lacking the basic academic qualifications also relevant to me. Only in the case of percentage of total qualification and taking into consideration reservation and has no place for in other words, it is the basic petitioner himself that apart from applicability to the of Deanship of 2000, the process of selection and governing regulation under the UGC regulation made in terms of section 41 states, made section 53 where to be followed, and in fact, the so separation of selection mandate that the selection out appointment who are found eligible in the future. Appointment by age, it is then that the selection of person will be enabled to consider between the this is the unacceptable
So according to you, even otherwise, the prioritization by age is at the time of appointment. When
List is prepared by the authorities, assessing the merits of each one of the candidates. So once that list is prepared, which is admittedly in 2019, much after I became given by the age factor reduction. Appointed by the authority. Can we take this paper of 15?
respondent number 3. 3. On? Yes.
Has incidentally pointed out in the beginning of the submission that it was my case. Some point of time in the initial speculative stage. There was a clear note about the speculative but the reason of not having at the academic. was also my submission. The change in the committee which was constituted for me. That was also the reason why there was a delay in the proceedings of the committee. During the boarding meeting, we had to my change. How change eligible academic.
Filed by,
Filed by the respondent, this respondent number 3. That's the contesting. On 10/6/2020.
Mr. Nagarajappa appeared for,
So the third response, I'm appearing for.
filed on 10/6.
10th June 2020.
Mm-hmm. 10/6. Yes.
When you come to page 4, Mr.
Annexure.
R3, page 4. Mr. Yes, is an assistant professor in the Department of Electronics Communication Engineering in Jawaharlal Nehru New College of Engineering. He has been working with me. So it's also very useful.
Summoning of records. 7/6/23.
Yes. That's the one. Here is some of the documents.
Page
Page 44
of
of this application calling for. Let's solve that this time.
correct, but it has only.
Sorry, which I absolutely am told I learned it as well. But the reason why was I wanted to show this thing that each one of the faculty members is a LSC PhD holder. There's no person who is teaching in this institution. But the engineering stream. So there is no person, no subject which he can teach. Every one of the faculty members who are teaching in this department, who are eight in number, are all persons who are science stream policy. The subject which is being taught in this institution is MSc science, MSc electronics. And degrees awarded as MSc electronics, same as he teaches the post leading to the in a science stream. There's absolutely no syllabus, nothing which will interactive particular to the faculty in this institution. And therefore, he faces instances merely because selecting a property as him in place and make him a person who can demand from the university, who being appointed when there is no teaching for people and the also to ask you what exactly is the top solution. These are the consequence of point. These are the sources. And in the light of the see that consideration is that doesn't have the policy and these for an element of the place. Like the place that is and over the full picture. not been satisfactory. And look, the proposition, the first proposition is in a given case, even if some action or other challenge to the restitution is found to be illegal, as the complaint of not applying it. So for exactly its extraordinary jurisdiction, with a view to doing substantial justice between the parties. Article 226 of the Constitution is an extraordinary review, which is essentially the function of although founded on finding out that A is actually employed to that termination. Place to accommodate them, but so is also trying to express the concept of person. And although founded on DP, it is perfectly open for the scope. While existing law, it is to be transferred with equity, and this equitable situation demands to settle the legal formula, not to take it to the legislature. The High Court would be able to duty if it does not make the equitable consideration and now the final outcome any other approach or render the common court which is not. In both the it needs to be the but here the state not to the the court would be the question of entertaining the in regards to Department of Higher Education. Acting upon the representation to the particular community and the status who are directed to take up no action of the petition to stop the specific It must be noted that the learning single rate is not addressed the question of local office efficiency or sustain the selection of the requirement. Clearly, the repetition of the question of consequence. Which aspect has not been addressed fully by the learning team. Number 4 is the statement shortlisted list. It is due to our grade the issue of our interesting response not raised before. Despite the need of six, in answer to the question and since then, most of the
Monday. Reply on. You can also, the records, you keep your records also. We list on Monday. Monday. Okay, 2:30.
My apologies, my lordship. I was not present in the morning session. Lordship, in this matter, as per my instruction, there is no correspondence by Lokayukta. Only on the ground, as per the CCA rules, he was behind the bar for 2 days, my lordship. So only he was behind the bars for 2 days, my lordship. Only on that ground, as per CCA rules, rule 7 something, we have suspended him. Suspension order is passed by BBMP. But the inquiry, because on the basis of a criminal complaint, inquiry was initiated by Lokayukta and proceedings have been continued in Lokayukta. Yeah, because BBMP has suspended him because he was behind the bars for 2 days, my lordship. So that is the reason.
How do you get over that rule?
Well, now he's on bail, my lords. If your lordship,
Correct, that is there, but then,
my lords, the order of suspension, my lords, if my lords, if it is passed, my lords, during while he was in custody, my lords, then my lords, they can rely on,
which is that rule?
my lords, rule 7, CCA rules, my lords, per se, my lords, is not applicable. He is an employee of the corporation. My lords, if they rely on any rules, my lords, it will have to be the Karnataka civil servants rules, my lords, not the CCA rules. CCA rules, my lords, are exclusively meant for government servants. He is an employee of the corporation.
No, they may have adopted.
No, they have not adopted, my lords.
Huh?
They have not adopted it.
But the rule, then you point out the rule now.
Now, under the Act, my lords, the corporation has to come up with their own section 105, my lords, of the BBMP Act. If your lordship so to peruse, my lords, section 105 of the BBMP Act, the corporation, my lords, has to come up with its own rules, my lords, governing the service conditions.
No, but then you point out what is the applicable rule.
Yes, Lordship, I will just find out and.
Have it on Monday. You point out what is the legal rule. Complete instruction, I'll give you time. Now we are on the point of seeking interim relief. So you point out under what rule, whether that rule, that if he's arrested, whatever, he's saying that you can pass that order of suspension only if he was still under the arrest, not later.
Not yet.
Monday.
That's
Monday.
fine.
Till such time, my lords, let them not, my lords, precipitate it, my lords. I have not been relieved.
I will instruct the officers.
Let
By
there be an
Monday,
order, my
because
lords,
of, because of this, there will be
if-
holidays. Nothing will be done, I believe.
my lords, if some other employee, my lords, is posted to my place,
No, now what has happened now?
my lords, order of suspension is passed. There is no other employee who is posted to my post. Now, in the interim, my lords, if they were to do it, my lords, then the whole purpose of filing the repetition, my lords, will be lost. Till such time, my lords, let them not precipitate. Till Monday, my lords, let them not precipitate. By Monday, my lords, I'll also place, my lords, the relevant rules, if my lords, they have.
Respondent not to take any precipitative steps to give effect to the order at annexure M till the next date. Relist the matter on Wednesday. Wednesday.
Obliged.
Obliged.
Before the respondent. This matter, lordship was pleased to hear this matter, my lord, last week and granted me an interim order till 28th, my lord. Because in between the petition, lord, they had passed an order. Lordship gave me liberty to challenge that order and an interim order was granted till 28th. I filed the petition on 25th itself, my lord. And I moved the matter on Monday, Tuesday also. But unfortunately, it did not list. I'm only requesting lordship that, my lord, since there was an interim order in my favor, Kindly have it on Monday, my lord. Till let them not precipitate, Monday I'll submit my submissions. Lordship may pass any order, lordship deems fit.
We'll have it on Monday.
Please, my lord.
Prima facie, there's no case anyhow. We'll have it on Monday. Respondents not to take any precipitative.
My lord, let there be not, let there not be an order, my lord. I'll inform them not to precipitate. Till now, my lord, till now, this moment, my lord, I know what has happened. But I'll inform them not to take any action till Monday.
Relist the matter on Monday.
Monday, great.
Learn from this one, so is directed to accept notice. Pramod.
No, my.
Your name.
Yes.
Contribution. Accepts notice for the respondents.
Please.
Relist on Monday in the preliminary hearing list.
Please, my lord. Great, great.
Office may be directed to reflect my name. The registry may be directed.
So the name of land council so and so is representing the respondents.
Great.
Yes.
Bill number 66, my lord. This matter was moved as my lord, it's put up for B group. Bill number 6. That's an order of recovery, my lord, from the petitioner. Without issuing any notice, my lord, this order is passed.
Yes.
Bill number 48.
My lord, I have received a. Sir. 48, my lord. There is an amendment, my lord, and as per this amendment, the director is entitled, he is the authority to pass orders for the rank below the assistant executive engineer and below, my lord. I have produced the notification.
So we'll hear the matter. Let us.
Your
He is
lordships,
competent to pass orders.
Correct. Let them take instructions.
no, your lordships, another document I want to rely upon.
No,
produced at my-
on merits we'll see. No
No.
order is passed.
No, your lordships, the competent authority who has issued sanction, prosecution sanction
No,
against
that,
me.
those are matters which require some hearing, not at this stage.
No, your lordship, the competent, page number 90 may be seen. Page number 90 of my petition.
No, what do you say regarding this?
He is not the competent authority. It's page number 90, the competent authority is the
They have-
superintending engineer. Superintending engineer.
No, what rank are you now?
Meter reader, my lord.
So director,
Yes, my
HR,
lord. Correct.
PTCL is the requisite authority.
In respect of all cases of employees of the rank of assistant executive
Your Honor,
engineer,
this is
equivalent and below.
This is dated 4 November 2020.
Yes, my lord.
And,
Correct.
and the document which I have produced, it is dated 9,
There is an amendment.
it
my
is
lord.
also 4 November 2020.
Let us see, it's a matter that requires
But till
consideration.
then, another ground is also there, your lordships, because in the inquiry itself, the complainant has turned hostile.
No, those matters not at this stage.
No, your lordship,
No,
the
those-
thing is,
Inquiry matters, inquiry is held. You will get benefit in case we
no, if
consider.
the order is executed,
No,
if the
nothing will happen.
order is executed,
Nothing will
and
happen.
till then, when
No, not as a matter of
directed
course.
not to implement the order.
I won't reject it. I'll keep it alive. Let them take their stand. We'll see.
Yes, my lord.
By the meantime, they will relieve.
That is okay.
He has not even collected the copy of the order, my lord, officially.
Consideration of interim prayer is kept open. Relist the matter. When will you file?
Next week, my lord.
Tuesday it may be taken up.
Tuesday, I will place instructions, my lord. I will submit my instructions. I will file statement in the coming week, my lord. Week after next.
Wednesday.
13.
Much obliged, my lords.
That's 60.
Serial number 62, Lord. It was on 28, my lord. At my request only, it is listed today, my lord. This is regarding selection of the associate professors to the university, my lord, Open University. Lord, the petitioners who approached before the Supreme Court in the writ petition, their applications have been rejected on the ground that they are ineligible to apply, my lord. They have approached the Supreme Court and suppressed the material fact. They obtained and stay order. And my lord, because of that, my lord, almost about 62 persons have been suffering.
And we have been called for an interview for 2 times. They are entry because of the interim order granted by the Honorable Court. We have been denied. Not that is the reason I requested from day before yesterday to today.
Serial number?
Serial number 62. There was an interim vacating application, Lord. 62, Your Lordship. I am appearing for the respondent 4 to 5, 4 to 7, 5 to 7, Your Lordship. The petitioner's applications have been rejected because of their ineligibility, my Lord.
This is the matter in the
Vacating application is pending, Your Lordship.
orders list
Grateful, my Lord.
on
Tuesday, may I request him?
6th.
Not serial number 63, Your Lordship. This is regarding the Karnataka employees for non-payment of salary since 11 months, Your Lordship. It was also,
It has been paid, deposited to the outsourcing agency as per this honorable court direction, and I'm placing the rest.
No, correct, but now you'll have to prevail on them to.
They have to collect it and they are refusing to give the copy of Aadhaar card, PAN card, and photographs and family details, because outsourcing agency has to give the EPF and other statutory benefits. For that purpose, the petitioners are not giving the information to the agency and they are not collecting the salary.
Lord,
The correspondence and the bank statements I'm producing.
Lord, the outsources order has been stayed by this Honorable Court. May I request, Your Lordship, ink page number 11 may kindly take the very same memo, Your Lordship.
We will have it on Monday.
May I request, my Lord?
Monday.
In the orders list, my Lord, may I request, please? Ma'am? Because the salaries, they are suffering 11 months.
Now they're saying that you go there, they'll give it to you. They've
The agency have refused to take the ink page number 11 may kindly see, please, ma'am. In the very same memo. Therefore, my request to Your Lordship, they never issue any memo because they have not at all approached us. They made the false allegations and they are denied to take the outsourcing, my Lord. That is the reason my request to Your Lordship. Let the salary may kindly be paid to my employer as usual till disposal of the writ petition. Because the outsources order has been stayed by this Honorable Court, my Lord. Ink page number 11.
It's been stayed.
Please, Your Lordship, it was stayed on 12/3/2024, Your Lordship.
The matter has been kept open and my specific contention was one, the Karnik is a society and it does not come under the writ jurisdiction and I disputed the maintainability.
Outsources.
And the honorable court said that keeping the matter of their admission, appointment to the outsourcing agency, they are permitted to take the salary. In fact, I had brought the check to this honorable court to show my bona fide intention, and court directed me to deposit it to the outsourcing agency, and I have done that.
Outsourcing agency is not made a party.
No.
No, my Lord, we are not aware that, my Lord, because there is an order passed by this.
Now, if any direction is to be given, why don't you make them a party? I'll give you permission now itself. Take out hand summons. We'll have it on Tuesday. If you're going to give any direction, let them be on record. Without
They have, may I request Your Lordship, ink page number 11, they have refused to take the outsourcing of these petitions, my Lord.
Because
Ink page
these
number
people
11, my Lord.
are
In the very same memo, my Lord. And they have returned the amount to the petition, to my employers, Your Lordship.
Let us see. Relist the matter in the orders list on Tuesday.
Grateful.
Please lodge.
If you want any direction against the outsourcing agency, you can make them a party.
No, we have not sought for any relief and against the outsourcing.
I'm saying,
Please.
If for any reason,
Please, Your
any
Lordship.
direction is to be passed by the court, why don't you make them a party?
Please.
The learned counsel for the petitioner, without prejudice to
My Lord, may I request Your Lordship?
contention raised, is permitted to array the outsourcing agency as an additional respondent. Necessary amendment to be carried out. Petitioner is permitted to take out notice to the said outsourcing agency by way of hand summons as well. Relist the matter on Tuesday.
Great. May I permit Your Lordship right now carry out?
Yeah.
Great.
Go to-
Serial number 66, my lord. Lord, there is an order, my lords, for recovery of money, my lords, from the salary of the petitioner. On the last occasion, Lordship had directed me to serve, my lords, the standing counsel, my lord.
Yes. Group C or wow, which Which grade you are?
My lords, without notice, my lord, this order is released. My lords, I am my lords group A, my lords, group A.
Group A.
Please.
Then whitewash, that one applies only to C and D.
C and D, my lords.
C and
However,
D.
my lords, this order, my lords, is passed, my lord, without my lords intimating me and without issuing notice to the petitioner.
So we'll have it on, in the orders list,
My lords,
We'll
from
have
the
it in
salary,
the-
my lords,
Yeah.
this month, my lords, salary, if it is recovered, my lord.
No, so we'll see, we'll have it on Monday.
My lords,
Let
till
us
then, my lords, let them not take any precipitative action, my lords, pursuant to this order, my lords.
No, but let us see what it is. Let's at least hear
Please.
what
Monday.
it- Monday. List the matter in the orders list on Monday. And Satish says we can redo it. Satish says, court has power to order for refund. Yes.
Lord, serial number 65. Lord, departmental inquiry charges are held to be not proved.
Yeah.
Lord, without issuing second show cause notice, penalty is issued. Lord, matter is covered.
List the matter in the orders list on 6th.
Interim order may be extended.
Interim order earlier granted is extended till the next day.
Serial number 55, my lord.
There's something I want to ask. Just wait. Serial number
55.
55.
It's a matter of filling up a backlog, this one, posts. So they filled up under new rules. Actually, our contention is it should have been filled up under old rules as per the Supreme Court directions. But there's only a 10 post backlog vacancies were there.
Objections are filed.
Objections are not filed. They have to give the instructions from the government. Yeah. Respondent for
Correct. You see, you take it in writing, you take your stand in writing. You're filed. 4 and 5. The respondent 4 and 5, even you and as well as the state to complete instruction and file the statement of objections by the next date. List on.
next Tuesday or Wednesday. Publish.
Under 252B,
Yes, my lord.
continuity in service.
Please.
For pension also.
Yes,
For pension.
yes. 252B is, my lord, technical resignation. My lord, the latest judgment is, my lord, LR Patil versus State of Karnataka, which traveled from our High Court. Lord, lien subsists till, my lord, probationary period is declared in the department where I have been selected or directly recruited. The service rendered, my lord, would count.
Would count. So they are saying that subsequently, if he is appointed
Yes, ma'am.
after taking permission and the pension must be under new pension, not old pension. When the petitioner contends that it's a continuation. Petitioner contends a continuation because he has taken permission. So he is still deemed to be in service. So while calculating the pension, you must take that into account. They're saying that the appointment subsequently done would entitle him only to exercise option of new pension, not the old pension.
It is not directly on the point, my lord. What it says is, my lien subsists,
In the first, just give it to the court.
LR Patil versus, my lord.
To the court of.